Kindly, seal number 66 of today's list.
66.
Today's list, finally. And on 3rd July also mentioned about the collection of toll by National Highways. Now, what I'm submitting, what happened 2 days back, there is a half-finished road, National Highway in Ankola. It a landslide happened because of the excavation work of the. So several people would have died. So they are actually audit report is also I filed on the court passed on 12th September 2022. Give response to that also. Because they are not halfway unfinished roads, they do it. They allow the traffic for the purpose of collection of tolls. Now 2 days back, the deaths have taken. Even the gas tanker had fallen down inside the river. So at incomplete road, they allow for collection of tolls for the purpose of only.
This is for challenging the virus of section.
It can be accommodated today or so that it can be taken up and because it's the end of the 230 list also some of the matters are there.
We'll see, let us.
Because today also I got the audit report wherein the rules still that framed by the rules have not been followed by the NHA. In 2013, they framed the rules also.
Hello, serial number 48, I think for, I undertake to file wakalat for respondent contempt, yes. And to file response in contempt. Yes. Yes, I have informed. Please, ma'am.
6th August.
That's one contempt matter, my lords, with regard to education. This was listed, my lords, in the last week of last month, my lords. It was adjourned as university mentioned that the SLP is pending, my lords. In the last week, SLP is dismissed, my lords. Exams are scheduled, my lords. Exams are already commenced, my lords, from Monday, my lords, last Monday. Hence, there is urgency, your lordship. May be taken tomorrow, my lords. Grateful.
One matter, my lord, I filed a memo for withdrawal of the matter. In some urgency, my lord, it may be taken up tomorrow.
Or withdrawal.
Yes, your lordship.
Wednesday.
Please, your lordship.
Next Wednesday.
Please, your lordship. Wait.
My lord, serial number 70.
Yes, ma'am.
Serial number 70, my lord. I'm appearing for the, appears to respond number 6. My lord, 6 for a short accommodation for the.
17.
70, my lord.
70.
2670. I have filed an impleading application in that, my lord. I'm the landowner. My lord, today's I have inconvenience, my lord. Any day next week, my lord. I've informed the petitioner and also other respondents, my lord. They have no objection to it.
Why do you want time?
My lord, today, my lord, my father's yearly ceremony is there, my lord. In view of that, my father's yearly ceremony.
All. Next Thursday.
Please, my lord.
My lord, serial number 71, my lord.
Grateful.
Lord, this
Serial
petition,
number 71, my lord. It may be heard today.
2:30. 2:30.
Serial,
Lord, this petition was filed.
serial number 2, my lord. There are subsequent developments. I am required to place it on record. I pray 3 weeks accommodation, my lord.
That admission, ma'am.
Please. There are subsequent developments. It's relevant, my lord.
You are for petitioner.
Please, my lord.
After the reply, we will not grant it. Very serious allegations are made.
There are subsequent developments.
What are the developments?
Subsequently, proceedings were held and some resolutions were taken up. I am required to place.
When the exams are going on to start?
That is not an examination matter. This is pertaining to seniority, my lord.
Serial number?
2, my lord.
Another list, which
List 1, my lord. Writ appeal matters.
I'm saying. Say in second list. All right.
My lord,
Serial number 23.
6th August.
my lord,
Please,
this, my lord,
Serial number 23, my lords. I appear for the respondent.
Serial number?
23, my lords, 23.
For the
Okay,
petitioner
fine.
in this case, my lords.
I've informed my learned friend. I undertake to file wakalat as well as my reply, my lords. May be granted 2 weeks' time to do so.
A week's time may be given, my lords. They are aware of the matter.
Please, my lords, I've been served only in this week, my lords. That being reasonable.
One session. Where it is? Return list is not being sent. Where is separate? You keep it separate. यहाँ है. No, the student. Yes,
Serial number 23, appear for the respondent, undertake to file wakalat. May be given 2 weeks time to file my reply, my lords, to the contempt petition.
My lords, for the petitioner in the same matter, my lords, a week's time may be given. They are aware of the matter from the month of April, my lords.
which matter?
Serial number 23, my lords. Serial number 23.
23.
Yes, my lords.
I've been informed about this only day before yesterday by the client.
You are also mentioning 23.
Please, please. I was informed by the client day before yesterday. That's the reason.
No
I'm-
objection.
please.
A week's time may be given, my lords.
7th August.
Blood.
Lords, this petition was filed challenging the impugned order of land of grant without following the due process in KLR Act. The matter was listed on 28th April and 3 weeks time was given to complete office objection, failing which the petition would stand dismissed. We have completed almost all the objections, but 1 or 2 were remaining because of the bona fide reason. And we have filed a necessary application to restore the petition. Kindly, it may be listed to here on IA.
Or what? Restoration.
Yes, restoration of the petition.
31st July.
Right.
Pull out and then. Pull out.
Number 89. The Dilip M.
So not to be placed before the bench where one of us, Honorable Mr.
List number 2, seal number 1. Chandrakant Argole.
I appear for petitioner, my lords. Your lordship entertained the similar matter and passed the detailed order, my lords. Your lordship entertained the similar matter and passed the detailed order. We are requesting my lords to pass the similar order in this writ petition also. Your lordship permits, I will pass over the order your lordship passed on 10/3/2000, 10/7/24 minutes. It is with respect to medical students transfer matter, my lords. Lordship permitted them to attend the classes as well as to take them exams on, which is coming on next month.
Where is the order?
Same college?
Same college.
Same college? Yeah, Germany.
East Point College.
Mr.
I'm for the
Ramesh,
respondent
same,
number 8 in this matter.
same order to be passed.
Well, this is with regard to the payment of the fee. Same order could be passed.
I'm for the respondent number 8 in this matter, my lord. I don't have any instructions regarding this one. It may be passed over, my lordship.
2/3.
Much
2/3.
230.
Seal number 2, Mr. BP Negde.
Made.
Appear for the respondent number 3.
It's by an order dated 19/6/2024. Your lordships had made an order permitting the student lots to pay the examination fee,
When the examination starts?
9th of August.
9th of August.
Yes, so seeking for permission to appear in the examination.
Let us. see.
Identical situation last year, your lords were pleased to permit them.
But now reply.
And in Ayurvedic college cases, lots, last week, your
Now
lords
the
have
objections,
They
objection-
have filed objection, they are relying upon an one-man committee report, which lots does not annul this candidate's admission. It only says refund the person who who it finds that wanted to take but he made a request for refund. Milords, we have corresponded with the concerned authority to fill this seat. It should not go wasted. This candidate, Milords, has the requisite merit and Milords was registered. with-
Entire premise of your petition is demolished by saying that student Mr. Teja Krishna never reported. It is an entirely false case.
No, that was the case.
Reported and somebody demanded 1.6 crores, a serious
It's
allegation.
all, Milords, without any basis. It's the statement. Milords, what we have tried to point out is that we have,
It is your affidavit.
I appear for respondent number 2, KEA, my lords, Karnataka Examination Authority. I have filed my statement of objections.
Milords, on 15th was the last date for admission. On 11th, we have repeatedly sent them the email to say that this student has not come. Please fill up somebody from the merit list. There's no action taken. What they say is that subsequent complaint is examined by the authority, the one-man fact-finding committee. And that committee also doesn't say this admission is bad. It only says they were denied admission based on certain self-serving statements made. For all that we are pointing out, Milords, it has imposed 5 lakhs fine. We are challenging that order. Milords have filed a separate writ petition. Unfortunately, it has not come with this. In the meantime, Milords, all that we are requesting is subject to the outcome of this. Please permit us to appear in the examination. Your Lords is under.
Read paragraph 5.
Order of the committee, Milord. The statement of objection.
Statement of objections, page 69,
Yes.
paragraph 5.
It is submitted that it is utterly false to state that the student SSM Teja Krishna had not reported to the second petitioner college as on last date of reporting to the college, that is 11/11. The said student has sent the email to KEA on 11/11 at 9:48 PM and on 12/11, in which she has clearly stated that on 11/11 she has been to the college for admission and college authorities demanded 1.6 crores for the admission, which she could not pay and hence they did not allow her to join the institution. Copies of the said email are produced here. Just stopping here for a moment. It's settled law that once a fee is paid at the KEA, it is a deemed admission. In terms of the regulations, Milords, of the KEA, if somebody does not report before the last date, his admission is deemed to have been cancelled, and under the consensual arrangement, that vacancy can be filled by KEA or by the college. The institution, Milords, has sent 2 communications to the authority saying that she has not turned. There is no answer to that development at all by the KEA. Milords, we have sent on 11th, on 13th, 15th was the last day to fill up these seats. That issue has not been debated, Milords, before the one-man committee. Let's see if in fact we had refused, the KEA could have responded to our communication saying that no, you have refused, then therefore admit. Question of Milords, our admitting doesn't arise, admission takes place at the KEA. It's only not having opted for admission. There may have been some development at her end because all that she wanted was a refund of her money.
You joined that side student, Teja.
I'm sorry.
Teja is a party?
Yes, Milords, the Teja is the petitioner. I mean, sorry,
No,
the
she's
person
not
who
a
was
party.
withdrawn.
On the last occasion, this honorable court had directed him to implead,
You implement, then if something can be done, if at all can be done, we don't know.
No, Milords, insofar as Teja is concerned, apparently she had joined some college in Andhra. Therefore, the request was to refund her money. I'll implead, I have no difficulty, Milords. Milords, I'll implead it today only, my lords, if it is necessary. Lords may permit us to do that, and lords may have it at 2:30, my lords. I will assist the court. All that we are anxious is, my lords, if she doesn't want the seat should not go wasted. That's the tenor of the judgments of the Supreme Court, my lords, in Index Medical College. Lords, if ultimately they find that I am not entitled to the seat after hearing, my lords, your lords may deny the benefit of this examination. I'll certainly implead now itself, my lords, I'll implead with the leave of the court.
Lord, may I submit?
What is that page 85 that I just wrote in the? There also it is repeated.
85.
Yeah. Correct.
This is 85.
Who is this direct?
But, my name is not shown in this, though NMC is shown as a party one. And I think this is also, there are two other petitions of this college also. The same college, two other petitions. And in the same vein as we had argued last time, my lord, the same malaise is for this,
The same college.
two other petitions of this college.
Yes.
This is a different college from what we have submitted earlier, my lord. But there are three petitions altogether if we include this. Again, in the same vein as the last time, we'll have to look at each of the admissions on its own footing and take it as it goes. Because from what we understand, since my name is not shown, I did not get the cause list. I was told, that's why I'm here now. But the admission has been made improperly, because if my lord sees the dates from what I recollect from the petition, my lord, it does not show that the admissions were made on the last date, before the last date, and the manner in which the admission was made, because they could not have been possibly been made. One is when the KEA sends the name, and the other, it appears, has been made dehorse the KEA.
My lord.
But anyway, I will have to take some instructions also on that.
Lords may kindly say annexure R1, which is the communication by the National Medical Commission, which says that there cannot be any physical mode of admission. It has to be going through KEA itself, my lords. That's the crux of the,
Through KE on.
please, my lords, they cannot make direct admissions. It's all there.
We are asking them to implead with student. Then we'll see what can be done. If at all something can be done.
It's me, lords, in view of the urgency, could your lordships permit us to amend and implead here, my lords, with the leave of the court?
After the order dated 19/6/24 came to be passed by the court, figures on record, the statement of objections filed by the respondent Karnataka Examination Authority. Full stop. In view of the paragraph, in view of the contents and averments. In view of the averments and contents made in paragraph 5 and paragraph 6. In particular, of the said statement of objections, learned senior counsel Mr. So and so seeks permission to implead student named SSM capital, Teja, THJ, Teja Krishna, Sri, SRW, as party respondent. Permission is granted. The course title of the petitions will be amended immediately. Notice shall be noticed to the newly added respondent, returnable on 30th July.
Could we, with the leave of the court, do it here in the court?
You can do.
My lord, for the NMC, my name may kindly be shown.
Name of learned advocate so and so shall be indicated on board as appearing from the National Medical Commission while notifying the petition on the next date.
So we'll take hand summons to the, because he's not here, he's in
Is
Andhra
appellate.
Pradesh.
Hand summons is permitted.
Additionally, my lords, with
Service
the,
by hand summons is permitted.
and the
to the
email.
Respondent.
List one. Still number one, contempt matter, Vishal Tiwari.
Yes.
But this contempt is arising out of another contempt, my lords. We had filed a contempt, my lords. The state had given undertaking that it will comply with the order within 2 months. Now that they have not done so, my lords, hence we have filed another
Lords,
contempt. my lords.
pursuant to the undertaking made by the state, my lords, we are in the process. Now, the government order is issued by the accused, my lords, requesting the other 7 departments to implement the order. Some of the departments have already issued the government orders in pursuant to this order.
Nothing has been placed on record, my lords.
Shall as in
I will-
hands
I
the
will-
copies of the order. Pass it.
Lords, there is an urgency, my lords, the urgency being, my lords, complaint. I'll look into it, my lords. I'll look into it. May I have it up tomorrow, my lords?
Tomorrow.
Tomorrow. my lords.
My lords, a week's time may be granted so that I can find.
We'll be withdrawing to.
No, no, my lords. Because last time also, my lords, they are given an undertaking.
We thought you are seeking time for withdrawal.
No, my lords, we'll produce what is this order, my lords.
So you can write now, so
I can.
unless you don't.
No, no, I know.
It is also in English and Kannada and all language you want to know.
Lords, may I make this submission in respect of 6 complainants we are
So how
implementing.
much?
There are 7 complainants.
How
In
much time
respect-
it is likely to be?
My lords, we are on the process, my lords. It will take minimum 4 weeks, my lords. Meanwhile, I will,
My lords, this is the year of my 20 years of back wages have not been paid, my lords.
Yes.
20 years, my lords.
6
Will-
departments
Not
are
in three, my
involved.
lords,
We
have
are
been
on
not-
the process. This is the GO issued for implementation.
You speed up the thing because earlier the court directed to complete within two months.
Please, my lords, since there are 6 departments, various departments involved. My lords, we are on, 2 departments have already, today they are reporting to
Within
duty.
further 2 months,
Please,
within further 2 months.
please, my lords.
My lords, there is an urgency, my lords. Complaint number 2, my lords, is undergoing chemotherapy, my lords. Doesn't have the money to pay his hospital bill, my lords. My lords, for the past 20 years, my lords, they've not been paid a single amount, my lords, from the government. And my lord, this is the 9th round of litigation between the parties, my lords, and the single judge, my lords. I've come to a conclusion, the state is using instrumentality, my lords, to make sure that I don't get any benefits, my lords.
But they have to undergo their own process.
Yes.
My lords,
An
the
administrative-
October order, my lord, the writ court is
Of
of
the
October, my
files.
lords. The single judge, my lords,
They have started to comply with. It is not that they are sitting tight.
almost an year has passed by, my lords, from the writ court order. The writ court had directed, my lords, within 8 weeks, you have to pay
That's-
back wages. We had waited for 8 weeks, my lords, then we came before this court.
Already.
Again, they sought for 2 months, my lords. Now again, they're seeking
We'll
for 2
file
months,
a
my lords.
status report, what all process we have done, my lords. If some time maybe.
You want the court to pass an order or you just adjourn the matter? What do you want?
Take instructions, my lords.
Only
Because, my
two-
lords, last time, my lords,
No instructions. Only 2 options are available. Either we pass order in light of the process already undertaken to comply with and require them to complete the process within 8 weeks. Or you seek simple adjournment. Choice is yours.
I'll take an adjournment, my lords.
Adjourn.
I'll take an adjournment.
At the request of learned advocate for the complainant, whom has asked for stand over to
I'm grateful.
27th August.
Two urgent, still number 3, the writ appeal. Sticky.
I represent the appellant counsel. Connected appeal order. There were two writ appeals notes filed against the common order of the learned single judge. One is the present appeal, which is before your lordships, and another is writ appeal number 1231 of 2023. In which, my lords, it's 1231. 1226 of 2023.
1226
of 2020. In which, my lord, there was an interim order granted by your lordships, my lords, directing the respondents not to take any final decision in the matter. But the dispute, my lords, between the parties is this. There was one undivided milk cooperative society in the form of what is known as Kolar Milk Cooperative Society. It is basically an apex cooperative society, my lord, which procures milk from the primary shareholders, and thereafter, my lords, it is distributed, and the dividends, profits are distributed among its members. But the Kolar district itself was bifurcated into Kolar and Chikkaballapur in the year 2007. Revenue districts were created. But in the state of Karnataka, my lords, every district more or less has a separate milk cooperative society, apex body. Therefore, my lords, in the year 2016, this body, that is the Milk Cooperative Society, lords, passed a resolution seeking bifurcation of its unit into two units, namely Kolar Milk Cooperative Society and Chikkaballapur, which is the newly created one. But there were three resolutions which were passed, unanimous ones, which I may briefly bring to lordships' notice. 23/9/2016, 23/9/2017, 23/9/2018, almost at an interval of every year. Now, lords, under the provisions of the Cooperative Societies Act, whenever a division between a single cooperative society has to take place, approval of the registrar is required, lords. And accordingly, under section 14 of the Act, the Registrar of Cooperative Societies gave such an approval. May I request Lordship's attention to that order which has been passed by the Registrar at page 205 to 117. Operative portion of the order. In view of the factors described in the above proposal, section 14 of the Karnataka Cooperative Societies Act and government notification number so and so, in exercise of the powers conferred on it, I, Ashwath Narayan, Joint Registrar of Cooperative Society, subject to the stipulations set out in the order, hereby order that the Kolar is separated from the Kolar District, Chokkaballapur District Cooperative Milk Union. Now, consequently, two separate orders came to be passed. One, my lord, registering Kolar as a separate cooperative society. That, my lords, get at page 129. A fresh cooperative society was registered at page 129. That is Kolar District Cooperative Milk. At page 141 is the Chikkaballapur Cooperative Society. So there are two unions which were formed, Chikkaballapur and Kolar. Now it is these decisions which were called into question in the first round of litigation in writ petition number 13957 of 2022. The 13957 of 2022 was a writ petition filed by certain shareholders calling into question this decision or to bifurcate and separate registration. But I am informed to submit before your lordships that 13957/22 writ petition was heard by the learned single judge, and at the time when the matter was reserved for the judgment, this very officer files an affidavit before the court stating that he has withdrawn all these orders. That lordships will get it at page 99. Withdrawal order. Page. This is 26/6/2023. At page 100, lordships will get it. He says all the four orders are withdrawn. But this, the learned single judge, in fact, notices that is not a coincidence, but it was immediately after there was a change of political dispensation in the state. 23rd of March was the 23rd of May was the results. 26th of June is these orders have been withdrawn by the same officer who lords had issued the earlier orders. At page 100, lordships will get. This is done without notice to any of the affected parties, including the persons who are before the court. Now, this orders, my lords, were the subject matter of challenge before the learned single judge.
Of withdrawal.
Withdrawal of the original orders.
It is in a challenge.
That was under the challenge before the learned single judge.
Who are you?
Lord, I am the shareholder of this cooperative society, which has been subjected to. Number of them. We are all primary cooperative societies.
Another shareholder.
I'm
Another
sorry.
shareholder.
Yes, shareholder.
Not one who had filed.
Not one who had filed. We are other shareholders. But we were interested in this bifurcation for simple reason. Once there was bifurcation or two headquarters, our ability to go towards
This bifurcation or withdrawal of it, whatever.
Yes.
Either way. It appears to be an administrative act.
Section 14, lords, under section
Isn't
14.
it is the exercise of administrative power.
But so one of the contentions which we raised was, since it affects the parties, it should be considered as
How
quasi-
does it
quasi-judicial.
affect?
It does affect, lord, for this reason.
In terms of valuation of shares?
Yes, lord, valuation of the share, not only valuation of the shares, lord. In fact, lord, we are all lord, persons who collect milk from these milk producers and go and it has got huge administrative convenience, ability to come towards the officers, several other aspects. It was for that reason we said, not section 14.
What are the ground of withdrawal?
Yes. Now, he says, kindly see, lords, at page 99. Absolutely no reasons are given. He says a strong argument has been advanced by the petitioners. I take notice of that. No, in fact, matter was posted before the learned single judge for judgment. Kindly permit me to read that note, sir. Learned single judge, in fact, I need not say that. Not learned single judge himself states that this order is passed in the background of change of political dispensation. May I request lordships to kindly see the observation. He says a strong argument has been made. At page 93. Against the said order, so-and-so, Ulwadi has filed a writ petition number so-and-so in the Honorable High Court questioning the above division order and supplementary orders and has requested immediate injunction against all the orders. Throughout the hearing of the said writ petition, a strong argument has been advanced that the partition order should have been passed only after the property of the undivided union is also partitioned and distributed to the divided unions in the general meeting, which has decided to make the said division. But he does not issue notice to any of them.
What happened to that writ petition?
That writ petition, lords, came to be dismissed because the government withdrew this order. That writ petition was calling into question this very order, which the court would either way decided about the validity. What he does not, he preempts the court order and withdraws the government orders. So something which is, lords, completely depreciable, according to my respectful submission. When the matter is posted before the court for judgment, validity of the order, extensive arguments are held.
That doesn't appear to be an enforceable right.
But insofar as we
get it revived or
no, what actually happened, lords, is if this order had prevailed, but in fact, not the consequentially the societies had stood registered. We were enrolled as shareholders. Matter was going on. At that stage, my lord, he withdraws it. Number section 14, if lordships are to say, it looks, yes. It appears to be, lords, not merely an administrative order, but has quasi-judicial, lords, impact. Section 14, if lordships are. Section 14(1), a cooperative society may by a resolution passed by 2/3 majority of the members present and voting at a general meeting of the society, divide itself into 2 or more cooperative societies. We come in this. Now, let's the power of the registrar to approve this would be at subsection 4. When a cooperative society has passed any such resolution, it has been approved by the registrar. Subsection 3. The resolution of a cooperative society under subsection 1 or subsection 2 shall contain all particulars of the transfer, division, or amalgamation as the case may be. And no such resolution shall have any effect unless approved by the registrar. But it certainly affects the members of the cooperative society. Let us say a decision is taken which is contrary to the interests of the members or to the benefit of the members. Certainly it is the members who are affected. Therefore, an order which has been passed under section 14, when sought to be withdrawn, first submission was, there is no express power to withdraw. There is no express power given under section 14 to withdraw such an order. He becomes functus officio. He becomes functus officio once he has approved that and has allowed more consequential registration. That could have been only a matter of a challenge before the court, which they did actually by going before the court. Now what he does is withdraws when 14 on a plain reading, there is no such power. Number one. Even reliance under section 21 of the General Clauses Act, saying that whatever we have the power to pass an order has the implied power to withdraw also, my lords, must.
So registrar himself cancels.
He himself cancels without any authority. He withdraws that order at page 101. I brought to Lordship's notice. There is no such power.
Yes, who anybody appears?
I appear for respondents 1 to 3. My lord, paragraphs 23 and 24 of the order of the learned single judge may be seen, my lord, against which the appellants herein, who were not parties before the learned single judge, my lord, are aggrieved.
Paragraph 23.
Page 54.
Page
54
50.
of the appeal papers.
Yes.
My lord, the appellants could have participated in the proceedings before the learned single judge. My lord, if their interest was really affected, not having participated and trusting, my lord, the respondents. Paragraph 23 and 24.
Was there any breach of any kind of provision or statutory requirement while bifurcating?
Yes.
2/3 majority passed the resolution.
Was that?
Yes,
That is the premise on which the bifurcation is permitted.
yes,
Under
the
section 14.
resolution. Yes, yes,
Then it leads to an approval of the registrar.
yeah.
Then what was that?
But may I, I'm sorry to interrupt, but may I request Lordships to kindly see internal page 27, page 51. That's how the learned single judge himself records, page number 51, internal page 27. It is obvious. But top, not at the top. It is obvious that the JRC has passed the order at the instance of the political bosses who were at the helm of affairs. Such an illegal order cannot be permitted to be revived only because the subsequent order of withdrawal is also.
Bifurcation order.
No, he says about the withdrawal order. Learned single judge in fact records that the bifurcation order was passed at the instance of political bosses. He says only because we don't. Kindly see the last sentence. It is noticeable that the impugned order dated 26/6/2023 is passed by the JRCS after the state saw a change in the political dispensation. But he in fact says this order is illegal. But then, Lord, for reasons saying that we do not have locus standi, we are mere shareholders. Therefore, the matter should now go back once again to the general body for reconsideration. He sends it back. This is plainly impermissible, according to. And my lords will kindly see the resolution is of the year 2017. Writ petitions are filed in the year 2023. But 2/3 majority resolutions are of the year 2017, 18 and 19. But registrar approves it under section.
Why 3 resolutions?
Sorry.
Why 3 resolutions?
no, three different resolutions. The first, my lord, initially they proposed it. Second, it was my lord, approved. Then third time it was reaffirmed.
But then the finding is in period 22 is that subsection 4 requirement is not.
Lord, that one, my lord, may I request lordships to kindly see section 14, subsection 2. But, no, that
1 month notice.
all was given. my lord. There was no challenge to that at all. My lord, may I my lord, there was no challenge to the resolution.
No, the subsection 4 contemplates certain conditions to be complied with.
Please, ma'am.
After registrar gives approval, namely notice to the creditors and shareholders.
Yes, ma'am. Any member, subsection 5 contemplates any member or a creditor who does not exercise his option within the period specified in subsection 4.
Yes.
And every member who has voted in favor of the option shall be deemed to have been assented to so and so. There was no challenge to this. There was no challenge. The whole object, my lord, is to give a creditor the
So nobody,
notice is
nobody objected.
nobody object.
No creditor,
No creditor object. If a creditor, no, there is no object, no, my lords. There was one, my lords, cooperative society named NSSDC. NDDC, that my lord had given no objection certificate as well. There is one of the creditors, they had given no objection certificate. That is placed on record.
Individual shareholders or corporate shareholders?
Cooperative, it was a cooperative.
No, corporate shareholders or individual shareholders?
It was a corporate shareholder. And they had given no objection certificate.
They have given no.
No objection certificate. But this para, lords, and lord, ultimately learned single judge holds one of the main grounds for dismissal of the writ petition is we did not have locus standi. He says shareholder cannot challenge the decision. Is how lords the learned single judge proceeds. But according to me, that runs contrary to the decision of the Honorable Supreme Court in R.C. Cooper's case, where their lordships hold that even a shareholder is entitled to move the court in case his rights are affected. But I am just made a small synopsis on that question, but I'll just place it before. Learned single judge at para 2 relies upon Daman Singh and state of UP for the purpose of holding that the shareholder may not have a right to challenge it. That lordships will kindly see at internal page 2. May I request lordships to permit me to read para 3 of this extract. Rustum Kavasji Cooper versus Union of India, para 3, kindly second para in that. By a petition praying for a writ against infringement of fundamental rights, except in case where the petition is for a writ of habeas corpus and probably for infringement of the guarantee under Article 17, 23, and 24.
Where you
I'm sorry, this is internal page 2 of that note.
Yes.
The decision is Rustam Kavasji Cooper versus lordships. Second paragraph, para 12.
Yes.
By a petition praying for writ against the infringement of fundamental rights, except in a case where the petition is for a writ of habeas corpus and probably for infringement of the guarantee under Article 17, 23, and 24. The petitioner may seek relief in respect of his own rights and not of others. The shareholder of a company, it is true, is not the owner of its assets. He has merely a right to participate in the profits of the company, subject to the contract contained in the Articles of Association. But on that account, the petitions will not fail. A measure, executive or legislative, may impair the rights of the company alone and not of its shareholders. It may impair the rights of the shareholders and not of the company. It may impair the rights of the shareholders as well as the company. Jurisdiction of the court to grant relief cannot be denied when by state action the rights of the individual shareholder are impaired even if that action impairs the rights of the company as well. The test in determining whether the shareholders that is right is impaired or not, impaired is not formal. It is essentially qualitative. If the state action impairs the right of the shareholders as well as of the company, the court will not concentrating merely upon the technical operation of the action.
Your grievance is only theoretical. Where is the impairment?
It is, Murad. Certainly, but in fact, it is.
Where is impairment?
No, it would certainly, Murad. My case was that, my lords, we must be permitted to be divided. We voted for
On
division.
the contrary, you said nobody objected under subsection 4.
No, nobody objected for the division. That is what I'm saying. Nobody objected for the division.
Division.
Division. We voted for division, but by division, what our share value certainly will go up. But it was go up. It is likely to go up. And apart from that, our right to participate as a separate unit, it was a long-standing demand. In fact, once the whole idea of a division was that the administrative office and everything else is closer to the people who participate in the functioning.
Would you like to file objections?
My lord, I'll take my instructions and make my submission.
Lords, I have only one request. Now, Lord, what this cooperative society does it, in fact, there is already an interim order passed in the connected writ appeal where lordships have directed them not to take any final decision. Now, Lords, on Tuesday, they have called for a, I won't use the word taking advantage, but having regard to the fact that matter did not appear before your lordship, they have called for a general body meeting on 23rd to take a decision. Either, I do not know what decision they want to revisit that earlier resolution or something like that. Therefore, we are seeking a restraint. Let them not take any decision until lordships decide that. 23rd, my lords, I am filing the translated version of the notice which has been circulated to all the members. And this is the subject they have kept for considering the matter, noting that the writ appeal is pending. English. It is in Kannada, but English translation has been provided. Lordships are to kindly see the
They are considering the issue of bifurcation only?
same issue, bifurcation or amalgamation, revisiting the original resolution or something like that. At page 17, lordships may kindly see 18. At page 18 of that English translation.
My lord, it's the respondent number 7 who has issued this.
Correct. That is the district court. Page 18, last paragraph.
It might be for the same purpose, bifurcation.
No, but it is not for that. In fact, they are opposing us. I'll be more than happy if they come before your lordships and say, we withdraw the earlier retrospective.
There is no point in calling if it is otherwise.
No, they have called, they want to take some decisions, is my instructions, but they want to take some decisions. One, in order to, then, once they reverse that original order, then
In seeking any interim order, you are running a risk.
No, I have been instructed that it is not for the purpose. But however, if they are to come before your lordships and make a statement that they agree for this bifurcation, but then the earlier government orders may have to go.
But
No, this specific
assisted by learned advocate, so and so.
I am also told that body's term has come to an end. And this is something which is come to an end in so far that now administrator has to be appointed.
My lord, notice.
There
by
are huge
Counsel for respondent number 7, my lord, who will be able to assist my lord with regard to, because the notice is issued by respondent number 7.
That is correct. That's correct.
Mr. Devi Prasad Shetty, my lord, may be copy.
Notice to all the respondents, learned advocate, Miss
1 to
learned
3, my
traditional
lord.
government advocate, Ms. Nindo Parakpal, accepts notice on behalf of
Respondents 1 to 3.
1, 2, 3. Returnable on, say 31st July.
Right, no.
Lords, we are seeking, Lord, let them not take any decision to be.
What did you pass over?
Yes, extra general body meeting, which is called on 23rd, Lords. 23rd, Lords, a meeting has been called by the 7th respondent society.
The petitioner here in appearance that. Where is that?
English translation. Not interim order. It's cooperative society memo.
The petitioner appearance that since Special general meeting is convened. On 23rd of July 24 by the Managing Director of the District Cooperative Milk Producers Society Union Limited. For the agendas mentioned. From any adverse decision. Any decision adverse to the petitioner may precipitate the controversy. In that view, it is observed that though the meeting of general body may proceed, it is clarified that if any decision adverse to the petitioner is taken, it will be subject to the final outcome of it. You got what you want.
Lords, I'll be more than happy if they come and say that they are ready to bifurcate.
But is there any pleading about this malafide or political?
No, earlier no.
So on what basis learned single judge?
Learned single judge holds, one is locus standi, of course, he says locus standi. Secondly, he says there was that general body, original general body meeting 2017, 18, 19 itself did not look like properly constituted. There is a stray observation made.
My lord, there is an IA 1 of 23 seeking leave, my lord, to the appellant.
Some of them,
Yes.
lords may issue notice on that also.
I am notice written on same date. On that day, we'll
Very well.
put an end to this one. Either way.
But this may be called along with the connected writ appeal. I will pass on them. There is a connected writ appeal, which this may be called along with that writ appeal.
So
1226.
To be listed on that day.
Yes, same. That writ appeal, lordships have posted it on 27th, lords, but
27th.
That is posted on 27th.
Connected. In
Yes.
what way connected?
Both of them arising from the same order. Another set of shareholders. Another set of shareholders have challenged.
You'll be able to serve.
Yes.
You'll be able to serve by 27th.
27th, we must be in a position.
Oh, like 27th.
Yes. I'm sorry. 26th time.
26th. We have no objection, but provided you are able to serve the others.
We will serve, Lord, by hand we'll serve. So that much.
Number 4.
I am for, my lords, I am for appellant counsel. Her husband is not well, my lord. She has taken him to Jaideva hospital. So she seeks for 10 days time, my lord.
August.
Number 5. Ajay Jain.
I'm for the appellant in.
Now to 2nd August at the request of learned advocate Miss Manjula Tejasvi for the appellant.
I'm for the appellant in writ appeal 395 of 2024. Lord, the as well as 359. Lord, in this, the appellant is a Schedule A Central Public Sector Enterprise, Lord, under the administrative control of the Ministry of Petroleum and Natural Gas. Lord, the appellant operates a refinery in Mangalore and was planning an expansion for a long time and had requested the respondent authorities, including the state of Karnataka and Karnataka Industrial Areas Development Board, to acquire lands. Finally, Lord, after the approval of the high-level clearance committee, it was decided that 1,050 acres would be acquired, out of which, Lord, about 820 acres would be for the expansion of the refinery. The balance would be to rehabilitate and resettle about 300, 400 families who were living in that area. Now, Lord, the main acquisition of 820 acres of land for the refinery has already been completed. The issue in this writ petition is for the acquisition of the balance area for the purpose of rehabilitation and resettlement. Now, my lord, the law relating to rehabilitation and resettlement is governed by an act called as the Right to Fair Compensation Act. Lord, a couple of provisions of that would be relevant. The Right to Fair Compensation Act. Lord, subsection 2, section 2, subsection 1 deals with the application of the act. Lord, it says the provisions of this act relating to land acquisition, compensation, rehabilitation, and resettlement shall apply when the appropriate government acquires land for its own use, hold and control, including the public sector undertakings and for public purpose, and shall include the following purpose, namely. So, Lord, the acquisition is by the Karnataka state government. It is for PSU like me. So therefore, there is the act would apply. Then, my lord, in the definitions under section 3, my lord, the first one, A, administrator would be of relevance.
But acquisition is set aside?
No, the acquisition has been made, but my lord, I raised the ground of the land being not suitable for the purpose of rehabilitation because it gets inundated. The topographical and terrain survey came much later. What exactly happened in this case was ultimately the cart was put before the horse. So the acquisition was made first and then the study was made. The study clearly indicates that the land is not suitable for the purpose of rehabilitation, which is why, my lord, I would like to demonstrate that
You are acquiring body.
No, I am the requiring body. That is, I am the beneficiary. Under this act, I am called as the requiring body. I am the requiring body. I am the requiring body.
Same, acquiring.
The beneficiary. My lord, if we have to go by the old act, I am the beneficiary.
There we use
Under the
acquiring.
new act,
For whose benefit, yes.
yeah, I am the beneficiary. My lord, just a couple of, my lord, provisions. Administrator, my lord, means an officer appointed for the purpose of rehabilitation and resettlement of the affected families under section 43(1). And then, my lord, appropriate government, E at the bottom,
Acquisition must have been upon your proposal.
Yes.
Then you must have proposed the very land.
Yes. No, my lord, in fact, my lord, I have got a very minimum role to play, my lord, which I'll demonstrate. I've got a very minimum role to play. Yeah. Particularly on the resettlement, my lord, I have zero role to play. It is the state, my lord, which has to first conduct a social impact study. And in this.
The acquisition starts upon proposal of the beneficiary or requiring body.
Yes.
You must have suggested the very land.
My lord, I'll come to that, my lord. My lord, there are facts, my lord. There was a consent, my lord. I have given my consent. My lord, I'll demonstrate that. My lord, please have a look at a couple of definitions which would be relevant for a lordship's consideration. My lord, appropriate government, my lord, at clause E, my lord, subclause 1 would be relevant. In relation to acquisition of land situated within the territory of a state, the state government. In this case, the state government would be the appropriate government.
Appropriate government. Yes.
And then, my lord, the other person interested may not be so relevant. Please have a look at ZB, requiring body. Requiring body means a company or a body corporate, an institution or any other organization or person for whom land is to be acquired by the appropriate government, includes so and so. Resettlement area means an area where the affected family who have been displaced as a result of land acquisition are resettled by the appropriate government. Therefore, the resettlement process is to be conducted by the appropriate government. Please have a look at subsection 4, my lord, which is very critical. Preparation of social impact assessment study. Whenever the appropriate government intends to acquire land for public purpose, it shall consult the concerned panchayat, municipality or municipal corporation, as the case may be, at village level or ward level in the affected area, and carry out a social impact assessment study in consultation with them in such manner and from such date as may be specified by such government by notification. The notification issued by the appropriate government for the commencement of consultation and of social impact study under subsection 1 shall be made available in the local language to so and so, so and so. Lord, then may I take your lordship directly to subsection 4. The social impact assessment study referred to in subsection 1 shall, amongst other matters, include all the following, namely A, assessment as to whether the proposed acquisition serves public purpose. B, estimation of affected family, number of families among them likely to be displaced. C, extent of land public and private houses, settlement and other common properties likely to be affected by proposed acquisition. D, whether the extent of land proposed for acquisition is the absolute bare minimum extent needed. Now, E and F would be relevant. E, my lord, whether land acquisition at an alternate place has been considered and found not feasible. And F, study of social impact of the project and the nature of cost of addressing them and the impact of these costs on the overall cost of the project vis-a-vis the benefits of the project, provided that the environment impact study, if any, shall be carried out simultaneously and shall not be contingent upon the completion of the social impact assessment study. While undertaking a social impact assessment study under subsection 1, appropriate government shall, amongst other things, take into consideration the impact that the project is likely to have on various components. Kindly have a look at the components such as livelihood of the affected families, public and community properties, assets and infrastructure, particularly roads, public transport, road, drainage, sanitation, source of drinking water, source of water for cattle, community ponds, grazing land, plantation, public utilities such as post office, fair price shop, food storage godowns, electricity supply, healthcare facility, schools and educational or training facility, Anganwadi, children park, places of worship, land for traditional tribal institutions, and burial and cremation grounds. And then, my lord, the rest. 5, my lord, is a public hearing for the social impact. 7, my lord, is the appraisal of the social impact assessment report by an expert body. And then 8 is the examination of the proposals.
This impact assessment study is with your participation.
Oh, no, my lord, as a requiring body, my lord, I don't have a role to play there. As a requiring body.
You are permitted to participate in process or assessment study.
As a consultee, my lord, yes. But fact of the matter, is, my lord, this social impact study has not been conducted.
What is the grievance? You are not wanting land now?
That's a.
No, my lord, my lord, I do want land, but I want a land which is suitable for the purpose for the resettlement. My lord, please have a look at a couple of more provisions, my lord, then I will proceed to the facts of the case. My lord, please have a look at section 11. Publication of preliminary notification.
You are not a person aloof of this process.
True, my lord, but my lord, I'm
in the sense that you are a participant to in some way, to some extent, in some manner, you are participatory.
True, my lord, my lord, the crux of the issue is, my lord, I am a refinery. I know I can only evaluate it from a physical perspective. But my lord, there are 2 other aspects which are very, very relevant. The terrain analysis and the topographical survey, my lord, which I don't have the expertise. And that conducted by the KDB, the respondent's authority, a report was issued which says that this land is not suitable for the purpose of resettlement. That is my main issue.
Who says that?
The KDB, my lord. The KDB, which acquired, my lord, has come out with a report.
Which body?
The KDB, the KIADB, that is the Industrial Areas Development Board, which acquired the land, subsequently conducts the assessment study and says this land is not suitable.
You are for whom?
No, I appear for the owners, my lord.
I'm for KIDB, my
I
lord.
appear for the owners.
You don't have any say.
But
You can't foist an execution.
no, my lord, I showed you not just the whole.
Can you thrust upon an acquisition on the somebody?
No, my lord, my relationship is with KIDB.
Who is for the state?
I appear for
What is
this.
your stand?
My lord, please take paragraph 24 of the order of the learned single judge.
Lord, I
at
take
page
your lordship to the facts, my lord. Let my learned friend finish. Your lordship will kindly see. This is all being done with, because they want to wriggle
not
out
gone to the facts,
of the
no, I will go.
acquisition. That is cannot be done. And my property, my lord.
The arguments, we are trying to know the boundaries of the.
The-
The boundaries,
contours of
my lord,
the
is
case.
that they want to now wriggle out of the acquisition because they find, my lord, it has become more expensive.
They want to wriggle out.
It has become more expensive. In
That's
law,
the ground.
can they be permitted to do it? And my lord, where I have been.
We'll consider.
My
What is
lord,
your?
paragraph 24, my lord, page 107 of the order of the learned single judge. From paragraph 24 to paragraph 31 may be seen.
If it is para 24, my lord, my learned friend is referring to page 107
Yes,
in WP 395.
the letter written by the owners, my lord, to the appellants.
But
What is this?
My lord, wherein they consent.
They are asking the owners.
Yes, the owners have written a letter to them, My lord, saying that they would like to, my lord, give their lands for the appellants. My lord, they have in their communication at page 108. That's the letter written by the landowners to the appellants. My lord, the last paragraph, since the land belonging to our family members, being a single plot, my lord gets it. Last sentence, we request you to forward your interest if it suits your requirement to us through KIADB. Paragraph 26 may be seen, my lord.
It is all right. That doesn't reflect on, that doesn't.
Miller, law is completely different. Law does not go by my suitability.
That they wanted, now they cannot turn around and say it doesn't.
Really?
And the report, my lord, does not say it is not suitable. The report of KADB that my learned friend point out to your lordship, my lord, does not say the land is not suitable.
We are going to see that only next.
The report only says it is going to cost you more money to make this suitable. Now, that is an understanding between KADB and the appellant under a different agreement, because KADB, my lord, was also engaged by them.
Now, at
As
what stage this acquisition is?
acquisition is over, my lord.
Acquisition was completed in 2017.
This is the
2020.
No, this is, I will give you lordships a few dates, my lord, if your lordships will kindly see.
We'll extensively hear one by one.
Yes,
Just trying to.
my lord, possession was taken from us.
No, my lord, I'm the appellant. My lord, I'm the appellant. I would like to lead the argument.
2018.
But I have not even gone to the facts. I do not want my learned friend to.
No, I won't.
My lord,
Do I want to, after some gap of some period, you are going to back
no,
up?
that's the moment we came to know about the report, which says, which points out the unsuitability. My lord, what happens is the area next to that, there is a hilly region. So when it rains, the rain flows down and it gets inundated.
Which place?
The Mangalore, near Mangalore.
Mangalore.
Mangaluru. It is very close to a river. The river water overflows, it gets inundated. So whatever we do, my lord, at the end of the day, which is why I read the aspects that the state government had to consider, whether it is possible to have drains, roads, post office, hospital there. My research submission, my lord, whatever we do, we may spend 200 crores and build something, but due to consistent inundation, my lord, everything will get spoiled. It is not in public interest. And learned single judge has never considered from the public interest angle. My lord, he only goes by fraud. I raised 3 grounds, my lord. I said the owner fraudulently withheld this information, which my lord, learned single judge turned down. The second was the suitability, whether the land is suitable or not. Learned single judge does not return any finding on that. And I also very categorically raised the issue of public interest, that acquisition of this land, which is not suitable, is not in public interest. And the learned single judge has not returned a single finding on that. So out of 3 issues, my lord, fraud, suitability, and public interest.
Compensation is yet to be paid.
I'm sorry, my lord.
Compensation is paid.
My lord, we had deposited 50 crore and we had sought stay, but because I could not get the matter listed, my lord, they have withdrawn the amount.
Then what will happen? How to set the clock back if you are right?
The fourth respondent will have to return that money, and my lord, at best, my lord, if he has suffered any damage, my lord, there is a civil consequence. I mean, because of us, my lord, if he has suffered any civil consequence, if his land, he could not deal with his land for a period of 4 years.
Taken.
I'm sorry, my lord.
Possession is taken.
Possession is taken. Possession is taken.
2018.
KDB has taken. I have not been put in possession. KDB has taken. My lord, these are all, my lord, vacant lands, my lord.
Award has been passed.
It's a vacant land, barren land.
Award passed in 2023, sir.
Award was passed only in 2023. My lord, the point that I would like to make is, my lord, there is a chronology in the act which says that there's 11 deals with the preliminary notification. Then, my lord, consideration of the impact, the social impact. Then, my lord, the final notification has to be issued only after completion of the social impact. Only after the completion of the study of the social impact. In this case, my lord, the state and the KDB went ahead and acquired first and then conducted the social impact study. which they have not completed. They issued some preliminary report. Therefore, my lord, the argument that the other side is banking on is that I, as the requiring body or as the beneficiary, I have already consented. But that is not the law. Law does not say if the requiring body consents, you can proceed.
So under this 2013 Act.
Yes.
Vesting vesting.
Please have a look, my lord. Please have a look at section 11 onwards.
At what stage?
My lord, I'll take your lordship through that. Vesting takes place much later. But please, I will quickly run through the few provisions, beginning with, my lord, the chapter 4 deals with notification and acquisition. Under that, my lord, there are a few sections, beginning with section 11. Publication of preliminary notification and powers of the officers thereupon. Subsection 1. Whenever it appears to the appropriate government that land in any area is required or is likely to be required for any public purpose, a notification, hereinafter referred to as the preliminary notification to that effect, along with details of the land to be acquired in rural and urban areas, shall be published in the following manner. Then there is a process which is laid out. Now, please have a look at 12. Preliminary survey of land and powers of the officer to carry out the survey, not very relevant. 13 deals with payment of damages. 14, lapse of social impact assessment report, may not be relevant.
12.
Please.
See, sir, to do all such acts to see a land is adaptable for such.
Yeah, I mean, I may take your lordships back to 12. Preliminary survey and powers of the officers to carry out survey for the purpose of enabling the appropriate government to determine the extent of land to be acquired. It shall be lawful for any officer either generally or specifically authorized by such government in this behalf or his servants and workmen to enter upon and conduct survey so-and-so, dig borewell, to do all other acts necessary to ascertain whether the land is adapted for such purpose, to set out the boundaries of the land proposed and to mark such levels of boundary, so-and-so, so-and-so. Then, Lord, please have a look at 15, hearing of objection. Any person interested in any land which has been notified under subsection 1 of 11 as being required or likely to be required for public purpose may within 60 days from the date of publication of the preliminary notification object to the area and suitability of the land proposed to be acquired, justification offered for public purpose, findings of the social impact assessment report. Lord, so this was not available to me at that point of time. And then Lord 16, preparation of rehabilitation and resettlement scheme. Lord, this is very critical by the administrator. The administrator is appointed by the state under section 43. What he has to do? Upon the publication of the preliminary notification under subsection 1 of 11 by the collector, the administrator for rehabilitation and resettlement shall conduct a survey and undertake a census of the affected families in such manner and within such time as may be prescribed, which shall include particulars of the land and immovable properties being acquired of each affected family, livelihood lost in respect of land losers and landless whose livelihoods are primarily dependent on the lands being acquired, a list of public utilities and government buildings which are affected or likely to be affected where resettlement of affected families involved, details of amenities and infrastructural facilities which are affected or likely to be affected where resettlement of affected families involved, and finally, details of common property resources being acquired. The administrator shall, based on the survey and census under the subsection 1, prepare a draft rehabilitation and resettlement scheme as prescribed, which shall include the particulars of the rehabilitation and resettlement entitlement of each landowner and landless whose livelihoods are primarily dependent on the lands being acquired and where resettlement of the affected families involved, a list of so-and-so, details of public amenities, so-and-so. The draft scheme referred to in subsection 2 shall include time limit for implementing the resettlement and rehabilitation resettlement scheme. The draft scheme referred to in subsection 2 shall be made known locally by wide publicity in the affected area and discussed with the concerned Gram Sabha or municipality. A public hearing shall be conducted in such manner as may be prescribed after giving adequate publicity about the date, time and venue for the public hearing. And then 17, my lord, review of the so-and-so scheme. Collector shall review the so-and-so scheme, my lord, missing. Then 18 deals with approval. The commissioner shall cause the approved scheme to be made available in the local language to the panchayat, municipality or municipal corporation as the case may be, and the offices of the district collector, subdivisional magistrate and the tehsil, and shall be published in the affected area in such manner as may be prescribed and uploaded on the website. 19 is the culmination. Publication of declaration and summary of rehabilitation and resettlement. When the appropriate government is satisfied, after considering the report, if any, made under subsection 2 of section 15, that any particular land is needed for the public purpose, a declaration shall be made to that effect along with a declaration of an area identified as a resettlement area for the purpose of rehabilitation and resettlement of the affected families under the hand and seal of the secretary to the government or of any other officer duly authorized to certify its orders. And different declaration may be made from time to time in respect of different parcels of any land covered by the same preliminary notification, irrespective of whether one report or different reports has or have been made wherever required. Collector shall publish a summary of the rehabilitation resettlement scheme along with the declaration published to in subsection 1, provided that no declaration under this subsection shall be made unless the summary of the scheme is published along with such declaration. Provided further that no declaration under this subsection shall be made unless the requiring body, that is me, deposits an amount in full or part as may be prescribed by the appropriate government toward the cost of the acquisition of the land. Provided also that requiring body shall deposit the amount promptly so as to enable the appropriate government to publish the declaration. This is the final notification within a period of 12 months from the date of publication of the preliminary notification under section 11. In projects where land is required in stages, the application for acquisition itself can specify different stages for the rehabilitation resettlement, and all declarations shall be made according to the stages so as. Every declaration referred to in subsection 1 shall be published in the following manner. Then 5. Every declaration referred to in subsection 1 shall indicate so and so, my lord. We may move to 6, my lord, subsection 6. The declaration referred to in subsection 1 shall be conclusive evidence that the land is required for a public purpose, and after making such declaration, the appropriate government may acquire the land in such manner as specified under this act. Where no declaration is made under subsection 1 within 12 months from the date of preliminary notification, then such notification shall be deemed to have been rescinded, provided that in computing the period referred to in subsection, any period or periods during which the proceedings for acquisition of land were held up on account of any stay or injunction by order of any court shall be excluded, provided further that the appropriate government shall have power to extend the period of 12 months in its opinion, circumstances justifying same, provided also that any decision to extend the period shall be recorded in writing, and the same shall be notified and uploaded on the website of the authority concerned. Therefore, my lord, as your lordships would see in subsection 6, it is only after the declaration made regarding the rehabilitation resettlement scheme that the government may acquire the land by publishing the final notification. So my respective submission is that essential step has not been followed. The R&R scheme has not been drafted. It has not been circulated. Opportunity was not provided. Primarily, my lord, the cart has been put before the horse. Lord, for me, it is a valid ground to challenge the very acquisition. If an essential procedure which is not followed, statutory procedure is not followed, Lord, I get a ground to challenge it. Regardless of the fact that I may have consented. Not I consented that yes, from my refinery, this is 4 kilometers away, 5 kilometers away. I gave that consent. But fact of the matter is, does the law say that based on my consent, the acquisition should be made? No. The acquisition process, my lord, there is a chronological process. My lord, very logically laid out procedure which is laid down. The question, my lord, before your lordship is whether the respondent authorities followed that procedure. If they have not followed that procedure, my lord, I have got a right to question the very acquisition. Now, my lord, may I take your lordship to the report of the authority, the KDB authority. Lord, that's in volume 2. No, who wrote this? Who wrote this? ಯಾವುದೋ ಒಂದರಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡಿದ್ದೀನಿ. ಓಕೆ, ಇದ್ರಲ್ಲಿ ಮಾರ್ಕ್ ಆಗಿದೆಯಾ? Public for acquisition, my lord, expansion of the refinery. Expansion of the refinery. Expansion.
One portion is for bulk of the acquisition is for both.
Total, my lord, the proposal was about 1,050 acres. Out of that, my lord, 880 was for the refinery. The balance 170 was for the resettlement, rehabilitation and resettlement, as an offshoot of the acquisition.
312. This letter explains everything. Once the word between the
Would your lordship have a look at volume 2, my lord, the report which points out the unsuitability?
No, my lord, well, kindly hear me, my lord. I point out your lordships how vexatious the whole proceeding is. Kindly give me a few minutes time. I want to point out your lordship some dates, and the entire reading of the statute, my lord, by the other side is incorrect. Rehabilitation, my lord, is for the benefit of the affected person, namely the family members of the person who has lost the land. My lord, rehabilitation is not theirs, my lord. Kindly see, this is why my London friends seem to think that rehabilitation is for the benefit of their employees. No,
No, that's not my
my lord, let me complete if you don't mind. My lord, rehabilitation as contemplated under this statute of 2013 is rehabilitation and resettlement of the affected family. My lord, yes, it was meant for the purpose of their employees. Yes, but that is not rehabilitation under the statute.
No, that was not my submission. My learned friend has misunderstood my submission. Yes.
Rehabilitation as contempt.
No, that itself is rehabilitation.
Let us be clear, my lord.
land losers.
Colony for the land losers.
Land losers.
That is for their colony. Yes, colony is not rehabilitation under the statute. Well, let it be clear.
Colony is the rehabilitation.
Page 3.
No,
that itself is rehabilitation.
No. Yes, let them, in fact, my lord, acquisition has been done.
Colony for
Final
people whose lands have been
declaration has
lost
been
here.
done. Possession taken, and I want to give your lordships a few dates, my lord. Kindly see how vexatious the whole thing is.
No, if my learned friend thinks that my submission was, the colony was for my employees, he is wrong, my lord. That was not my submission. The residential
That's how the
colony.
submission was made.
Resident,
All those provisions.
Sir, you got it wrong totally. This is for the people displaced. People.
Exactly.
No, that is the law, my lord. They have to be rehabilitated. They have to be rehabilitated.
This is what
the
I'm
people
saying.
from 820 acres, they have to be rehabilitated. True, I am not concerned, but I have to. Otherwise, my lord, then my lord, if that is, then I don't have to acquire the land. Why am I acquiring that 170 acres?
They are not acquiring the land, my lord. The acquiring.
No, it is not for them.
No, it is not for them, Lord. It is for the land losers of the 820 acres. Those, my lord, those are the displaced families. We have to resettle them elsewhere. To resettle, we need more land. And that is the 170 acres which we wanted to acquire. And that has to happen at my expense. I have to bear the cost.
I showed you, my lord, this is an acquisition under the KIDB Act. Let us be clear, my lord. I don't understand why we are referring to the provisions of the 2013 Act. Compensation is only under the 2013 Act as per the judgment of this honorable court in a connected writ petition. The acquisition, my lord, is under the KIDB Act. The whole reference to all these provisions under this act is
KIDB has a policy which clearly says principles of the 2013 Act would apply. And section 2 of the 2013 Act is very clear. It applies to every single acquisition for public purpose.
I want to point out to your lordships a few paragraphs of the judgment of the learned single judge, my lord, which will lay bare the facts.
against the suitability. Volume 2, my lord, volume 2, your lordship take. Volume 2, please, sir. The very first page, my lord, in volume 2, page 312. Lord, it's a one-page letter. I will read it and then go to the report because that laid the foundation for the report. This letter issued by the chief engineer of yes.
There is a separate agreement, my lord, between MR. This all been noticed in the order of the learned single judge, and I will point out your lordships, my lord. There is a separate agreement under which KIDB has been engaged by MRPL for the purpose of development, not an acquiring body. Implementing, and there they say we want little more money. Now, because KIDB says we want more money, it is their contract. In fact, KIDB would be their contractor now.
KIDB is the acquiring authority.
It has been recorded.
KIDB is the acquiring authority, not a contractor.
KIDB wears two hats. One is acquiring body, that's over. KIDB has also been engaged by them as a contractor for the purpose of doing the development. KIDB says, I want more money. Now, the moment KIDB says, I want more money, these people say, I don't want this land itself. This is not what can be done.
But I agree on that analogy that my learned friend gave. Anyway, Lord, please have a look at the letter dated 22nd December 2022 at page 312. It's written by the chief engineer KDB to the general manager of the appellant. Lord, he says, Karnataka Industrial Development Board under section 28(1) of the so-and-so act by notification dated 21/2020 has acquired 811.90 acres of land belonging to various survey numbers of Kutetur, so-and-so villages for MRPL, proposed phase 4 expansion project. Further, by notification dated so-and-so, has acquired about 171.06 acres in Mulur and Kandavara in Mangalore Taluk for formation of rehabilitation and resettlement colony for phase 4 project disabled families, displaced families. So therefore, it is not for my employees, it is for the displaced families. MRPL in their letter dated 36/2021 has requested KDB to take up the development of R&R colony in the acquired land, and 374th board meeting held on 24/8/2020 has considered the request of MRPL for development of R&R colony of Messrs. MRPL so-and-so. Now, as per the site condition, it is proposed to development of R&R in extent of 95.02 acres. KDB has engaged Messrs. Alcon Consulting and Engineers for the preparation of detailed project report. Accordingly, consultant have visited and inspected the proposed site, and after detailed topographical survey and site investigation, consultant has prepared detailed project report. The same was vetted and corrected by the board. After incorporating the corrections, observation raised by the board, consultant has submitted final detailed project report. The final detailed project report submitted with consultant along with the detailed note, which is self-admit, is herewith forwarded. And my lord, what has been forwarded is the next page, page 314. My lord, in that para 101.0 is the background. Please have a look at 2.0, location and terrain status. Proposed residential layout of R&R project site is located.
If your lordship will let it, kindly see 1.0 second paragraph. What I mentioned is mentioned there. Page 233.
Hello, I'm reading 315. I'm reading 315.
That the 1.0 second paragraph. What I mentioned to your lordship that KDB is wearing two hats. Is mentioned.
Why I skipped this is already there in the letter that I read. Lord, the first three paragraphs are exact copy of the letter, which is why I'm skipping that. Lord, please turn your lordship's attention to para 2.0. Location and terrain status. The proposed layout of R&R project site is located at latitude so-and-so. The site is situated southern side of Gurupura village, and it is 3 kilometers away from Mangalore International Airport, about 13 kilometers from Mangalore KSRTC bus stand, 14 kilometers from Mangalore railway station, and 12 kilometers from Palombic Beach. The terrain of the 95.05 acres identified for residential layout under R&R project of MRPL is in a valley portion. The soil is predominantly brownish red with laterite soil. The Gurupura river is running east to west of the project site, and as per the local observation, high flood level of the river during rainy season is between 5.65 meters to 5.75 meters, and in the same location, the ground level of the project site is about 2.50 below the bed level of the river. Now, please note the rainy season, what level it can, 5.65 meters into about 3.2. would be about close to about 20 feet. In addition to the above, there is stagnation of silt water in all major part of the project site, along with the thick weed and shrub. As mentioned earlier, the project site is in valley portion, and during rainy season, due to gushing of large quantity of water into the valley portion, the project site resembles a big lake or a pond. The detailed assessment of the project site was carried out, noting the features such as land use, probable alignment, habitation, water routes, utilities such as electrical lines, HTLT, etc. for better execution. 3.0 Topographical survey. Topographical survey was conducted using total station equipment and a contour map prepared showing contour line drawn at 0.5 meter interval, indicating all the prominent existing features such as roads, railway tracks, colonies, independent houses, power lines, water bodies, farms, gardens, fields, etc. with a few reference stones marked on the survey map and their level being enlisted. As per the survey, the least level of the project site is 2.061 meter and the least contour value is 2.5 meter as per the established permanent benchmark near the site. The terrain of the proposed resident layout of 9.5 acres is in a valley portion. Note below the image, the proposed layout bed of 2.5 meters at D point, there is stagnation of water at major portion of layout with thick weed and shrub growth. Further, during rainy season, high volume of water run into the valley portion, creating a lake-like scenario. And then, my lord, the next 2 pages, my lord, existing photographs are shown, and where lordship will notice that literally it resembles like a lake. There are about 8 photographs, about 10 photographs. All of them show the inundation. And then, my lord, the narration continues at page 322. As per the terrain and the survey carried out, it is observed that the residential layout is not viable on the project site. However, board consultant has, yes, Lord, page 322. Page 322, immediately after the photographs. As per the terrain and the survey carried out, it is observed that the residential layout is not viable on the project site. However, board consultant has prepared the layout plan of residential layout in an extent of 95.02 acres for the proposed development of rehabilitation and resettlement colony with the following land use analysis. Residential site so-and-so, commercial amenities, park, road so-and-so. Development works for formation. The proposed residential layout for development of rehabilitation resettlement colony in an extent of 95.02 acres is in a valley region with Gurupura River flowing from east to west, having high flow level of 5.65 to 5.75 meters, and at the least level is 2.061. Hence, it is necessary to bring the formation level of layout of the high flow level of the adjacent river by rising to the extent of 3.3 meter average to avoid flood and formation of the ponds. Now, Lord, here, although he suggests that this action can be taken, the consultant does not say that this will completely prevent. He does not assure that once this is done, there will be no further flooding. He doesn't say so. Then he gives further suggestion. And then finally, my lord, please have a look at the conclusion at page number 324. It is opined that the project site selected is not ideal. My lord, page 324, the bottommost part, my lord, the last paragraph. Page 324. You can't say that. In view of the above, it is opined that the project site selected is not ideal for residential. I think some part.
Ideal location.
Typed copy. I'm sorry, my lord, there's some portion is smudged. But my lord, the long and short of the conclusion is that the opinion is that the project site selected is not ideal for the development of residential colony. And then, my lord, he gives a suggestion that in order to make the conditions better, my lord, please have a look at the language used there. In order to make the project site conditions better for residential purposes, so-and-so expense has to be incurred. He merely says to make it better.
No, next sentence, sir.
The extra expenditure required for the complete development of the residential colony of Messrs. MRPL will result in about 30 to 45% increase.
30 to 45%.
Increase over an ideal site.
Increase over an ideal site for the same purpose. My lord, this report was issued on 22nd December 2022, and the land was acquired by KDB in 2020. My lord, what this report indicates, although this is not a very detailed report, my lord, what this indicates is that there is a valley. My lord, when there is a, what valley means is, it means that on either side of the land, there are hills or mountains. That is what a valley means. So when it rains, obviously the water has to flow down. The water flows down from the hills on the both sides and collects in the valley. And my lord, he also points out that the river level can go up to 5.75 meters, my lord, which can translate to about 20 feet. 20 feet, my lord, can inundate even electricity poles.
Keeping in view the aforementioned alternate locations.
Okay. I'm sorry, my lord, now I got the clearer version of the conclusion, where, my lord, the conclusion is, keeping in view of the aforementioned reasons, it is opined to opt for an alternative location instead of the present proposed site. However, if it is still desired to continue with the same proposed location for the development of R&R, it is to be noted that huge expenditure will have to be incurred by MRPL, which does not seem to be a viable choice. Lord, please look at the categorical statement that it is opined that it is not suitable and one must go for alternative. Then he says, all right, if you are still insistent, if you still have to go ahead. So when there is a valley, my lord, and Bangalore, my lord, during rains, my lord, it is not like Bangalore. It rains for days together. It doesn't stop. 6 months a year it rains. My lord, I have my roots from that area. I've lived there. So it rains continuously. So there will be inundation. My lord, what if finally, if the residents say, we don't want any plots here? My lord, I form, a colony is formed for which I fund. And finally they say, we don't want this. Am I then at that point of time required to go looking for an alternative land? What will happen to the investment made? Is it in public interest? Lord, these are the questions, my lord, which your lordships will have to consider. It is, my lord, I am not shying away from forming a R&R scheme or to resettle the displaced people. I am going to, my lord, that is my required statutory duty to do it. I am bound to do it. But then, my lord, can the fourth respondent, on the ground that I have at some point of time declared that the land is suitable, hold me to a ransom and say, no, you have consented, land has already been acquired, so therefore you have to now form on it. Not please weigh that interest of fourth respondent against public interest. At best, my lord, what will happen if your lordships were to set aside the land acquisition? The land is restored back to fourth respondent. The only, what he may have suffered is the value of the land. Lord, he may say, unnecessarily, you embroiled me into litigation. My lord, there is a civil cause of action for that. On the other hand, my lord, please weigh the consequences here. My lord, crores of rupees is spent and ultimately it inundates and it is found unsuitable or it leads to death or damage to lives and properties. My lord, which is that authority, my lord, who has conducted a survey and prepared a report and given me beyond reasonable doubt a report saying that please go ahead, you spend this amount, your site is guaranteed, no inundation will take place. For example, I understand that if somebody has to form an airport with a runway, they study the history of the land for 50 years, 60 years, and then conclude that this is a safe place. My lord, has such a study been done? My lord, there is one consultant which has conducted the study. If the consultant can say, then, my lord, if a full-fledged environment impact study is made, I'm sure, my lord, the result would be that this land is absolutely unsuitable for forming of a colony for people to live. My lord, the suitability of the land and the public interest was never considered by the learned single judge. My lord, let me show to your lordship the questions that the learned single judge framed and how he proceeds to answer them. My lord, he frames 3 questions, my lord, which your lordships will find at page 101. On hearing submissions of the learned senior counsel for the parties on perusal of the records, following points arise for consideration. 1. Whether MRPL has made out a case for quashing of notifications dated 15/12/2017 and 25/11/2020, insofar as they relate to lands referred to in the award dated 7/7/23 and consequently the award dated 7/7/23 on the grounds as urged in writ petition. My respectful submission would be this question would cover the issue of fraud, the issue of suitability of land, and the issue of public interest. Two, whether the landowners are entitled for the direction to the respondent authorities to disperse the compensation amount of 197 crore 28 lakh 34,758 as per the general award dated 16/3/23. Whether MRPL is a necessary party to writ petition filed by landowners. Not before that, I'm sorry, would your lordship please have a look at what averments I made in respect of the non-suitability and the public interest in my writ petition. Lord, for that, would your lordships kindly turn to page number 165. Lord, the para 30A, Lord, I'll begin from para 30A. There are just about 4 or 5 paragraphs that I'm going to read. In para 30A at page 165, Lord, my averment is, there has been a fraud of gigantic proportions perpetuated by fourth respondent in connivance with certain KDB officials at Mangalore, by which completely useless and waterlogged land was masqueraded as useful industrial land by creation of a false report, which formed the basis of the acquisition of land. The acquisition was done on the basis of consent of the petitioner, which was obtained by fraud. Until December 22, the petitioner was not even aware that the land was completely waterlogged and totally unsuitable for any kind of residential purpose. As soon as the petitioner has come to know of the same, petitioner has sought for deletion of the land as early as 4/1/2023. Photos showing the land are produced. The land is inundated and waterlogged for 6 months a year and not suitable at all for resettlement, rehabilitation of any person. The respondent number 4 has actively misrepresented and induced other respondents into acquiring the land. Acquisition of land is hit by malafide and misrepresentation, fraud played by the respondent number 4. Then, my lord, would your lordship now kindly have a look at para 37 in page 168. Para 37, page 168. The respondent number 4 has stage managed the entire acquisition of inundated and unsuitable land for making ill-gotten gains and a windfall. Hence, the impugned award, which is passed without considering the ground realities and relevant facts, is unsustainable in law. And then, my lord, about 2 more paragraphs, para 40 and 41, and then 42. My lord. Para 40 at page 169. My lord. 169. The petitioner has made representation dated 29/2023 by Annexure P seeking dropping of the land, as the land is not at all suitable for the purpose for which it has acquired, that is for resettlement and rehabilitation of persons who lost their land for industry development in the state. And this acquisition will cost the public exchequer heavily, where there are umpteen suitable land parcels are available in and around the project site. It is learned that the land, even if it is filled to bring up above the water levels of the nearby river and developed with estimated cost of about 225 crore, still it is inundated with floods and inundation during every rainy season. Given this understanding, the petitioner fears that the prospective rehabilitant and land losers will refuse to get settled or rehabilitated in this land, resulting in cascading public interest litigation. It is also apprehended by this petitioner that as the land is unsuitable for rehabilitation, all the money spent for the public exchequer will go into wastage. The development that could be made here with such public money may get essentially washed away in floods that may occur in future. My lord, here I have related to the elements of public interest. 41A, the acquisition process is vitiated by fraud and malafide, inasmuch as respondent number 4 has played fraud on KDB and the petitioner herein. Hence, acquisition process ought to be struck down on the ground of fraud and malafide. And finally, my lord, one more public interest government at para 42. I'll conclude with that at page 171. Not page 171. In an event of inability of the petitioner to rehabilitate and resettle the project affected families in R&R colony proposed as the land being unsuitable, the project envisaged by the petitioner will never become a reality. The entire cost of acquisition so far incurred and further envisaged budget for the industrial expansion project, which necessarily would fetch employment for hundreds of citizens as well as social and economic development for the state and the nation as a whole, would also in such event become a mere never fulfilling dream. So, my lord, I raised three grounds: fraud played by the fourth respondent, unsuitability of the land, and the public interest angle. Lord, your lordship would now notice when I take your lordship through the findings analysis by the learned single judge.
What is the fraud played?
Lord, I had alleged that the fourth respondent did not disclose about the inundation.
Fourth respondent is?
The landowner, the land loser of the land which is acquired to, my lord, the person who has taken away the deposit.
Was it the duty?
I'm sorry.
Was it the duty
My
of
lord, the learned single judge rejected, my lord, he has conclusively rejected my submission on that. On fraud, my lord, I may not stand on a very strong ground. Fraud against him. Because the question is, my lord, he is also not an expert. And he very categorically in his letter, he says, if you are interested, if you find it suitable, you buy. So with that, my lord, perhaps his duty of disclosure may have ended. But my lord, the larger question is, my lord, the suitability of the land for a public purpose. And my lord, whether the public interest in fastening this land on me was considered by the learned single judge. My lord, the findings of the learned single judge on the report, my lord, your lordship will find at para 43. My lord, can we begin from para 41 at page 119? Where, my lord, he sets the area in dispute. My lord, at para 41, learned single judge notes, necessary also to note that total extent of land acquired by MRPL is in excess of 1050 acres. The dispute in these petitions is only to an extent of 49.87 acres, which is owned.
Where you are reading?
Lord, 41, para 41 at page 119.
119.
Page 119. A handwritten page, not the internal page is 66. The inked page is 119.
Correct, 119.
Para 41, my lord. Necessary also to note that the total extent of land acquired for MRPL is in excess of 1050 acres. Dispute in this petition is only to an extent of 49.87 acres. As such, contentions vehemently urged on behalf of MRPL that this parcel of land is not viable and the same would saddle the public body. Public case with additional finance also cannot be countenanced. And then there are 43 on the next page. Perusal of the said report would reveal that the same is prepared by Messrs. Alcon Consulting, Bengaluru, who is engaged by KDB for the purpose of preparing a detailed project report, along with the technical and economical viability in respect of 95.2 acres of land. Para 4 of the said report, under the heading Development Works for Formation of the Residential Layout, refers to the said extent of 95.2 acres of land being in a valley region with river Gurpura flowing from east to west, having high flow of 5.65 to 5.75 meters, requiring bringing up level of the layout to high flow level of adjacent river by raising to an extent of 3 meters to avoid flooding and formation of ponds. It also refers to additional cost of 49.56 crore for the purpose of raising ground level and rupees 35.45 crore for requiring to retain and keep intact the peripheral embankment of the layout by building a retaining wall. The said report, as rightly pointed out by the Learned Counsel for the landowners, is only a report with regard to the cost involved in the development of the project. The report does not support the case of MRPL with regard to the land being unviable or unfeasible for the project report. In any event, the said report is issued by KDB, is issued through KDB, the said report is issued through KDB, nor as an not as an acquiring authority, but admittedly as an agency which is engaged in to implement the project. The learned single judge is just brushing aside the issues of non-suitability by characterizing this report as a mere report of cost. He has completely ignored very categorical statement that it is unsuitable, that there is rainwater, that there is the high level will be up to 5.75 meters, and the proposal to increase is only up to 3 meters. What happens to the remaining 2.75 meters? The advice is to raise the extent of the land only by 3 meters. If it reaches the high flow level, then there is inundation of 2.75 meters. Learned single judge, he very casually, he brushes aside the report on the ground that it is just a report of the cost. And then, my lord, he also proceeds to note at para 45, at para 44, he refers to the memorandum of understanding that had been entered into between the appellant and KDB. And after referring to that, his analysis at para 45 page, ink page 122. Learned Single Judge notes, the aforesaid documents have no doubt that MRPL and KDB were aware of the nature of land to be acquired and the responsibility and the consequence of the terms of the contract entered into between the two, even as on 12/5/2016. At any rate, these documents, correspondence would not give any ground for quashing of acquisition or setting aside of the award as sought for by MRPL. When the initial MOU was entered into, we had no idea of the terrain analysis or the topographical survey. That squarely fell, the responsibility fell on the state and the KDB to conduct the topographical survey and the terrain analysis. I can only have a physical look at the land and say this is 4 kilometers from my project and this is okay. These two very, very critical exercises, the topographical survey as well as the terrain analysis, was not conducted. And the learned single judge, merely on the basis of the MOU, says that I cannot wriggle out of the, cannot seek quashment of the notifications. And at para 49, my lord, learned single judge considers the element of fraud. And he concludes the issue there. Page 126. Page 126, para 49. From the holistic reading of the aforesaid material, it cannot be said that the landowners have perpetuated fraud by making false representation knowingly, recklessly, and carelessly. Thereby, they have induced MRPL and officers of responsibility to acquire the subject land as sought to be contended. The allegation of collusion between the landowners and officials as of KDB also cannot be countenanced in view of the participation of MRPL in satisfying itself with regard to the location, nature of the land, further requesting the government to acquire the said land parcel. Thus, in view of the above material records, it cannot be accepted that MRPL and officials of KDB were misled and induced by the landowners. Reliance placed by this learned senior counsel for MRPL on the judgment in Royal Orchid case are of no avail. For the aforesaid reason and analysis, this court is of the view that MRPL has not made out any grounds for granting of relief as sought for. Point number 1 is answered accordingly. Your lordships will see that at para 49 onwards, where the learned single judge has concluded, not his analysis is confined only to the element of fraud. He does not consider the suitability of the land, nor does he consider the public interest angle. Although his question was quite broad enough. The question that he framed was whether MRPL has made out a case for quashing. And in making out a case for quashing, I raised 3 grounds: fraud, suitability, and public interest. His analysis is confined only to one of them, which is fraud, to the exclusion of suitability and public interest. Point number 2, my lord, is a different question that dealt with whether they are entitled for direction to release of the amount. And the third question was whether I am a necessary party or not. So the learned single judge has not at all considered. But there is one judgment of the Honorable Supreme Court which I found, which comes close to the similar facts and circumstances, where, my lord, the Kolhapur Municipal Corporation wanted to acquire the land, but only difference is there it had not acquired, but the principles would apply.
Issue to acquire unsuitable land. Supreme Court set as a pleading is at page 772.
Page 772. Lord, just to take your lordship through what the case was, would your lordship have a look at para 4.7? None failure than either mark. Para 4.7, my lord, at internal page 772. It is submitted, lordship got in 4.7.
Yes.
It is submitted that it was pointed out that unless and until a major development which is carried out upon the said reserved land for making it suitable for the public purpose as per reservation, landowner cannot still say that the land must be acquired, which otherwise is not suitable. It is submitted that if such a request of the original land, this not be learned. I think, no, I'm sorry, my lord. The facts are at page 3.1, just two couple of lines, my lord, page 767, 3.1. Para 3.1, page 767. In this para, my lord, about fourth line from top, beginning with the words different. Different portions of land in question were reserved in the sanctioned development plan for various public purpose, namely parking, garden, extension of sewage treatment plant, etc. That as the land in question was not acquired and or used for public purpose for which the same was reserved under the sanctioned development plan, original writ petitioner landowner served a notice under section 127 of the Maharashtra Regional and Town Planning Act as so and so. Then, my lord, one relevant aspect would be right at the bottom, para 3.3, the last line in para 3.3 also informed that the land under reservation fell within the flood affected area, due to which proximity to Jayanti Nala and considering the valuation of the said area per market value of 2016-17, the amount of compensation was reduced from so and so to so and so. And then para 3.5. According to the corporation, the reserved area was coming within high flood line, and every year for a period of 15 days to 1 month, the said area gets flooded during rainy season. According to the corporation, the reserved land stroke area is flood affected, and a rivulet named Jayanti Nala passes through the said area under the reservation. Therefore, as per the corporation, before the TDR proposal could be considered, it was necessary to carry out the required development work upon the said reserved land for making it suitable for the public purpose as per the reservation to be carried out by the original writ petitioner landowners. According to the corporation, if the said developments are not done, the land and the reservation will not be able to be utilized for the purpose for which it is reserved. There were various correspondence between the parties. Now, my lord, let me take your lordship straight away to the findings at para 40, page 788. Just two paragraphs, about two and a half paragraphs, Lord. Para 40, page 788. Even otherwise, in the facts and circumstances of the case, the High Court erred, and or the High Court was not justified in directing the para 40 municipal corporation to acquire the land in question and to issue a declaration under section 19 of the 2013 Act. You know, this is the same act that I placed reliance upon, and to pay compensation under 2013 Act. It is to be noted that right from the very beginning, it was stated in the counter before the High Court that the land in question was not suitable and or usable for the purpose for which it has been reserved. It was specifically pointed out that the subject land is flood affected through which a rivulet named Jayanti Nala passes, making it unsuitable for the public purpose for which it was reserved. It was also specifically pointed out that unless and until substantial development is carried out, the land in question is not usable at all. It was also specifically pointed out that the reserved area is coming within high flood line, and every year for a period of 15 days to 1 month, the said area gets flooded during rainy season. In that way of the matter, High Court ought not to have directed the corporation to still acquire the land and pay compensation to the original landowner, though the land in question is unsuitable and unusable for the public purpose for which it has been reserved. As observed herein above, as such, at the time when the planning was made and the land in question was put under reservation for public purpose, a duty was cast upon the planning officer to consider whether the land which will have to be acquired and for which the compensation is to be paid is really suitable or usable for the public purpose for which it is reserved. Otherwise, every landowner will see to it that though his land is not suitable and not very valuable, is put under reservation, and the same is acquired for by the corporation and the planning authority, and thereafter he is paid the compensation. What follows is critical, my lord. No corporation or the planning authority or the appropriate authority can be compelled to acquire the land which, according to the corporation planning authority, is not suitable and usable for the purpose for which it is reserved. My lord, I am emphasizing on this proposition that, my lord, the decision of that planning authority or the corporation will have to be considered. Any other interpretation would lead to a colorable and fraudulent exercise of power and cause financial burden on the public exchequer. And then, my lord, para 43, the last 4 lines. Even otherwise, in the facts and circumstances of this case, when the land is found to be unsuitable and unusable for the purpose for which it has been reserved, the corporation cannot be compelled to pay huge compensation for such a useless and unsuitable land. Lord, I must concede that a couple of facts are very different here. One here, in the present case, my lord, the land has already been acquired. There it was reserved. But my lord, what I'm trying to borrow is the proposition that there is no point in acquiring a land which is not suitable or unusable. And my lord, the next proposition is that the planning authority or the corporation cannot be compelled to acquire the land according to which, my lord, where the corporation feels it is not suitable. And I have, my lord, gone on record giving clear reasons as to why the land sought to be acquired is not at all suitable for the purpose of rehabilitation and resettlement. Therefore, my lord, I have sought for quashing of the acquisition notifications. To summarize, my lord, my submission is that the 2013 Act, Right to Fair Compensation Act, will have an application by virtue of Section 2, subsection 1. Lord, the acquisition is for a public purpose. The moment the 2013 Act applies, my lord, the procedure laid down for the social impact study and the drafting of the rehabilitation scheme, my lord, takes center stage. If that mandatory procedure is not followed, and without following that, if a land has been acquired and subsequently it has been found that the land is not suitable, then, my lord, it constitutes appropriate ground for nullifying the acquisition. And that is exactly what I have sought. Before the learned single judge, my lord, the policy of the state government was produced. My lord, in the writ appeal papers, it is not included, my lord, by oversight. My lord, please have a look at this industrial policy, which very clearly lays down that the guidelines of the 2013 Act will have to be followed for acquisition of land. My lord, in the compilation that I have now handed over, at page 79, my lord, item number 5, policy measures. In that, my lord, specifically 5.1.1.2.
Under the KAD Act, there is no requirement of doing R&R because of the incorporation of the Statutory.
My lord, standalone, the Industrial Developments Act, my lord, does not have the concept of R&R. The R&R is a principle, my lord, which is borrowed from the 2013 enactment.
Rehabilitation and resettlement.
The rehabilitation and resettlement is borrowed from 2013. My lord, my stand is that it applies. Section 2 is very clear, it applies. Which is why, my lord, all of us have conducted this exercise of acquiring the additional land to rehabilitate and resettle. Since, my lord, learned single judge has not considered at all the two critical aspects of suitability and the public interest angle, my lord, the impugned order is liable to be satisfied. I'm grateful to you.
Completed.
I'm sorry.
Completed the.
I have completed for now. For now, I have completed. I'll come back after my learned friend.
Lord, I appear for the, Lord, first let me clear a few aspects on which my learned friend address your lordships, my lord. Lord, this acquisition is under the Karnataka Industrial Areas Development Act. The whole approach, my lord, in my respectful humble submission is referring to the 2013 Act is wrong. Please be kind enough to turn to section 28 of the KAD Act. And your lordships, my lord, put a question to us, when does vesting take place? May I place for your lordship's consideration, my lord, section 28, the KADB Act. And I showed your lordship the notifications that have been issued, under which act, everything I showed your lordships, my lord. And only to the extent of compensation, 2013 Act, nothing more. If at any time in the opinion of the state government, any land is required for the purpose of development by the board.
So this is under this act, notification under this act.
No, my lord, this is under this acquisition was under the KADB Act.
And
Yes, my lord, I showed your lordship the notification.
so then how this 2013 act comes into?
I don't know. Learned friend is referring to your lordship. That's why I kept quiet, my lord, when he was referring to it. It doesn't apply at all.
Then we don't
Come
need
on,
his
one-
land. Then we don't need his land. If resettlement and rehabilitation does not apply, then I don't need his land.
No, my lord, there's a complete misunderstanding with due respects to my learned friend. of the concept of rehabilitation and resettlement. Rehabilitation and resettlement as contemplated under 2013 Act is insofar as the affected persons are concerned, the displaced persons of the land which is acquired under that act. It is not, my lord, suppose, my lord, the factory wants to provide a colony for its workers. That colony is not for resettlement. Or, my lord, suppose they want land for the purpose of resettling those who lost lands for the purpose of their factory. That, my lord, is a public purpose. It is not, my lord, a resettlement or rehabilitation. They call it resettlement and rehabilitation, not as contemplated under 2013 statute. I take your lordship to the provisions, my lord. This acquisition, my lord, is under the KDB Act. And I showed your lordship the preliminary notification, the final declaration, all that is there. And the award passed, possession taken, and in this case, my lord, what happens is KDB is not the acquiring authority. KDB, my lord, does not have the power to acquire. The doctrine of eminent domain does not apply so far as KDB is concerned. The acquisition is made by the state. The state hands it over to KDB. KDB in turn hands it over to whoever wants it as part of industrial development. That is how, my lord, the Honorable Supreme Court has also explained it. I'm going to show to your lordship the judgment also, how the scheme of this act operates. And if at all there is any grievance, in fact, my lord, if I may say so, I think the appellant, my lord, the petitioner before the learned single judge has barked up the wrong tree. It is not a case where they should ask for quashing of the acquisition. It is a matter between them and KDB. My acquisition is by the state handed over to KDB. I have to get compensation. If they don't want to pay compensation to KDB and want to say, we don't want this land, it is a matter between them and KDB. Well, I have nothing to say. If KDB wants to return the money which they have paid, of course KDB can do it. Why am I, how does it concern me? I got my money not from them. So far as the land loser is concerned, I did not get the money from MRPL. I got the money from KDB. How KDB got it, my lord, is not my concern. So how does the acquisition go is what I ask myself. If they want to proceed against KDB and do whatever they want to do, they can sort it out with them. And the law, my lord, also is that if a particular purpose set out in the notification cannot be achieved, land can be given for something else also. It need not necessarily be, they're not confined to the purpose which is mentioned in the notification. So how am I embroiled, my lord? I am a, if I may say so, my lord, the typical case of innocent bystander who gets shot between two conflicting fights. How am I concerned, my lord? And I have lost my land. 2018 possession had been taken. And now to say, you proceed against me, I will ask for damages.
Let us see the notification.
Yes, my lord. May I just finish, if your lordships will kindly permit me, my lord, to show to your lordships the scheme of 28. And then, my lord, I will show to your lordships the notification. But I will definitely do it, my lord. If at any time in the opinion of the state government, any land is required for the purpose of development by the board or for any other purpose in furtherance of the objects of this act, the state government may by notification give notice of its intention to acquire such land. On publication of a notification under subsection 1, the state government shall serve upon the owner or where the owner is not the occupier on the occupier of the land, and on all such persons known or believed to be interested therein to show cause within 30 days from the date of service of notice why the land should not be acquired. After considering the cause, if any, is shown by the owner of the land and by any other person interested in, and after giving such owner and person an opportunity of being heard, the state government may pass such orders as it thinks fit. After orders are passed under subsection 3, where the state government is satisfied that any land should be acquired for the purpose specified in the notification issued under subsection 1, a declaration shall by notification official gazette be made to that effect. On publication in the official gazette of the declaration under subsection 4, the land shall vest absolutely in the state government, free from all encumbrances. This scheme, my lord, under section 28 has in fact, my lord, been explained by the my lord, by the Honorable Supreme Court with respect to MRPL itself in a case that went before the Honorable Supreme Court. Just for that purpose, my lord, so that we have our good. All right, no problem. The question, my lord, arose in that case was as to whether a allottee or a beneficiary can participate in any compensation proceedings. And the Honorable Supreme Court held no. And then, my lord, the scheme of the act was considered. If your lordship will kindly turn to paragraph number 10. It is pertaining to MRPL itself.
The report which Mr. Kamath read
Yes.
was under which provision?
My lord, that is not under any statutory provision. As I indicated to your lordship's, my lord, there were two hats that KADB was wearing. One, my lord, as acquiring authority. The other, my lord, as a developer of the property. KADB also said
Engaged by whom? Them.
them. And that memorandum of understanding that your lordship saw reference was between MRPL and KADB engaging them as a developer of the property. And there is an agreement between them. That is the MOU. And that's why, my lord, that one paragraph I will read to your lordship that report, which says that. And the report is prepared by one Alcon Consulting, which report is not produced before the single judge. And that is why, my lord, KADB now wants more money from them for the purpose of executing the project. They don't want to be out of pocket. My lord, MRPL does not want to pay. In this crossfire between MRPL and KADB with respect to the commercials, arising out of the hat which KADB is wearing, not as an acquiring authority or a body under the KADB Act, but independently as a developer of property, I am now caught. And 170 acres is taken, my lord. Out of this is some 49 acres. That is suitable. This is not suitable. And I showed your lordship the correspondence. They say this is too expensive. We don't want this property because compensation to be paid is high, not because the property is not suitable. In fact, this grievance with respect to the land not being suitable or fraud or public interest, etc., has been raised only in the writ petition. In the correspondence earlier, the only grievance was, it is too expensive, I don't want it. Please see if you can drop this. That is no reason under which provision of law can a the beneficiary come and say drop the acquisition. If you still want to persuade KADB to drop it, by all means do it. I ask myself, how is a writ petition to quash the acquisition maintainable at all? Who are they, my lord, in the whole process? I ask myself. That is why, my lord, this judgment gives your lordships the sequence and how section 28 of the KADB Act operates. The right of eminent domain is not vested, my lord, in KADB at all.
Naturally.
Then if KADB has taken over and given me the compensation, and the land has been acquired by the state government and state government has handed it over to the KADB, KADB in turn gives it to them, and they are not able to develop it for some reason or that it costs more money. How does it affect my right, my lord, as a landowner to get my compensation on account of an acquisition which has been completed? That's a respectful question, my lord, I ask myself and place it for your lordship's consideration. All this, if I may say so, my lord, this argument of public interest does not lie here. It is a question of right to property so far as I am concerned, which your lordships are aware, my lord, Honorable Supreme Court says is part of human rights under Article 21. And look at my situation, my lord. But the possession taken 18, writ petition filed in 23. Tomorrow, my lord, years later, KADB says, no, I want a little more money. These people say public interest. How can I part with more money to you? Therefore, change your contractor. Maybe KADB is not competent enough. That's a different matter, my lord. That's between them, not for me. I showed your lordships the correspondence, my lord. Please permit me to just show to your lordships how the Honorable Supreme Court has looked at the acquisition under the KADB Act. Would your lordships be kind enough to turn to paragraph number 10, my lord, in this judgment? The short question. My lord, Justice Arvind got it, my lord. Paragraph number 10, my lord. The short question which is posed for the consideration of this court is whether respondent number 1, MRPL, who is simply an allottee of the land by the KADB, after acquisition of the lands under section 28 of the KAD Act 1966, was for the benefit of KADB, can be said to be a person interested under the provisions of the KAD Act 1966, and therefore was a proper party in the reference proceedings initiated at the instance of the original land owners. While answering the aforesaid question, it is required to be noted in the present case, the land has been acquired under the provisions of the KAD Act 1966, and the notification has been issued under section 28(1) of the KAD Act 1966. The land has been acquired by the state government for KADB under 3 different notifications. After the lands were acquired, respondent number 1, MRPL, has been allotted the lands acquired as per the agreements entered into between KADB and MRPL. The present is not an acquisition under the provisions of the Land Acquisition Act, and therefore, as such, neither section 50 of the Land Acquisition Act nor any other provisions of the Land Acquisition Act 1894 shall be applicable with respect to the lands acquired under the provisions of the KAD Act 1966. Taking into consideration the aforesaid factual aspects, the impugned judgment and order passed by the High Court, in which it was heavily relied on the decisions of this court in UP, Avas Evam, are required to be considered. At the outset, it is required to be noted that as such, the issue involved in the present appeal in respect of the acquisitions under the KAD Act 1966 and the right of the subsequent allottee to participate in the reference proceedings, and whether the subsequent allottee can be said to be a person interested under the provisions of the KAD Act 1990 is no longer res integra. My lord, those judgments cited, I'm going to skip that, my lord, so that I don't...
So subsequent allottee is not a person.
No, that is the law laid down now. In MRPL's case, in fact, my lord, this judgment went to the Honorable Supreme Court from an order passed by the division bench of this Honorable Court. In fact, my lord, I had appeared in that case for MRPL, and an order had been passed saying that we should be heard. That order was set aside. And now, my lord, your lordship may kindly see para 52, my lord. Para 14. In para 14, there is a reference, my lord, to the judgment of the Honorable Supreme Court in Pirappa Hanmanta Harijan. In this court, in Pirappa Hanmanta Harijan, considered in detail the allotment lease agreement in favor of allottee lessee and also the relevant provisions of the KAD Act. Para 14, my lord. I'm sorry.
Yes.
I'm sorry, my lord.
Yes.
This court in Pirappa Hanmanta Harijan considered in detail the allotment lease agreement in favor of allottee lessee and also the relevant provisions of the KAD Act 1966, and as observed in para 50 to 54 as under. I'm going to skip 50, 51, kindly come to 52 at the bottom of that page. In view of the aforesaid documents, namely the notifications issued under 28(1) and 28(4) of the KAD Act by the state government, it can safely be concluded by us that the acquisition of land involved in these proceedings is for the purpose of industrial development by KADB Act in Sedam Taluk. Therefore, the beneficiary of the acquired land is only KADB and not the company as claimed by it. A reading of section 28(5) of the KAD Act makes it clear that the land which is acquired by the state government statutorily vests absolutely with it. That's what I point out to your lordship's lord. After following the procedure provided under section 28(6) and 7 of the KAD Act, the state government takes possession of the acquired land from the owners, persons who are in possession of the land, and transfers the same in favor of KADB for its development and disposal of the same in accordance with regulation 10A of the KADB regulations referred to supra. This is the scheme of the act. What happens between the beneficiary or the allottee makes no difference, my lord. Is a matter of arrangement between KADB and the beneficiary. Acquisition proceedings by KADB as an acquiring authority is not relevant. Now, my lord, now that I have shown to your lordships that this acquisition, my lord, is under the KD Act. Now let me show to your lordships, my lord. This is the notification under. Notification under. Notification is under which section? 23(1). My lord, your lordship may now kindly look at, your lordships ask me where is the declaration for vesting of the land. My lord, your lordship may kindly turn to page 217 of volume 1. Oh, my lord, the English translation is provided, my lord, I think at page 217. Your lordship got it. My lord, under authority of section, it should not be 23(1), my lord, I think it is a typographical error. In fact, it should be 28(1). The Kannada notification, my lord, is at page 195. It says 28(1). I think there is a typographical, my lord, it should be 28(1), not 23(1). Under the authority of section 28(1) of the Karnataka Industrial Area Development Act 1966. So, under notification number so and so dated 20th of December 2016. Well, that is the first notification under 28(1). Issued by the government of Karnataka by special gazette number so and so dated 29/12/2018. Government of Karnataka has expressed its intention to acquire the lands mentioned in the present notification for the 4th phase expansion of project of MRPL. So it is an expansion project of MRPL. Whether they use it for expansion, they use it for rehabilitation proposal, they use it for resettlement proposal, is their internal decision. This is meant for the project. How does all this come into the picture, my lord? All this comes into the picture because they went and told the KADB, we want to use it for this purpose, we will engage you as a contractor, therefore please give us a project report. And KADB says, give me more money. According to the current act, the order has been issued under 28(3). 28(3). And the details of the land mentioned in the schedule below are not mentioned in the notification. The government of Karnataka is convinced that they should be acquired for the purpose mentioned in the notification. It should be details of the land mentioned in the schedule below are mentioned. It should not be not mentioned. I think there must be again a mistake, my lord. It should be are mentioned in the notification. And then, my lord, my property is mentioned here. And it is this notification, which is dated, my lord, 15/12/2017, which is the subject matter of challenge in the writ petition. If your lordship will now look at the writ petition, my lord, at page 174. I'm sorry, page 173. It is this notification which is the subject matter of challenge.
Which one?
The writ, in the writ petition, my lord. It is this notification which is sought to be quashed.
Which one?
Page 173, my lord.
(173).
Yes, my lord. 173. It is, my lord, in volume 1 of the writ papers, of the writ appeal papers.
Prayer. Prayer. You are referring to prayer, I thought. Yes.
My lord, prayer, my lord. Yes, my lord. First one, my lord. prayer 1.
But then this 2013 provisions are not they don't interact, not at all.
That is only for the purpose of compensation between me and KADB. Because I filed a writ petition before this honorable court saying that my compensation must be determined as a converted land and under the provisions of the 2013 Act, and a mandamus was issued. And then when the mandamus was issued by this honorable court, I'm going to show to your lordship that order. The honorable high court said, issue notice before you fix the compensation to MRPL also. MRPL was issued notice. MRPL only came and said, it is too much. Can you see if you can denotify it? This was the reply. All this argument is now, my lord, made in the writ petition. When notice was issued to MRPL pursuant to a direction issued by the court with regard to fixation of compensation, KADB issued notice to MRPL. MRPL did not say the land is unsuitable, land is a public interest. Nothing was mentioned. Fraud, nothing was mentioned. All that they said was, this compensation is really too high. Therefore, can you consider if you can denotify it? And the law is very clear, my lord, that after final notification, there can be no denotification. That's all that there is end of it. Their grievance was only that much. They said, it's too expensive. Please denotify it if you can. So when I asked myself, with the foundation for all this submission that was made by the other side with regard to land not being suitable, public interest, fraud, and without fear of contradiction, my lord, I can say that the learned single judge has considered every one of these points. To say that the entire focus of the order of the learned single judge is only on fraud and the other 2 points are not being considered, in my respectful and humble submission, my lord, is not correct. And I showed your lordship the finding recorded by the learned single judge on all this. Look at the situation in which a person like me is placed. My land is gone. After 7 years, somebody comes and says, no, your land is not required by me. Give it back to KADB if you don't want it. If they don't want the land, give it back to KADB. Let KADB do what it wants with the land. I will get compensation from KADB. I don't care from where KADB gets the money. However, how is the loser of a land concerned with how KADB is going to deal with the property, or from where KADB is going to find money for the purpose of paying me compensation? It is a matter to be sorted out between them. And now, my lord, I want to point out to your lordship a few days.
It is already a time.
I know.
So, some other day?
My lord?
After recess or some other day?
Whatever. I'm at your lordship disposal.
25th.
My lords, KADB humble submission, my lords. Even we have filed on writ appeal, my lords. Writ appeal number 536 of 20%. It's the same subject matter, my lords. It may be connected to this petition.
KDB has also challenged the. KDB has also challenged the order.
KADB has challenged this order.
KADB has challenged.
Yes, they have challenged.
24th.
Why?
We have not been served.
Oh.
That
And in fact, KADB, my lord, has filed 2 statements of objections. I want to show to your lordships how interestingly KADB says, yes, we will take action against our officials. Do it. Do whatever you want, my lord. How am I concerned with all that is happening in this crossfire between MRPL and KADB? Innocent bystander is me. I am being harassed. I lost my land. I don't get compensation.
Let us see what KADB says in his appeal.
I'll show your lordship the very well. Of course, your lordship, look at it.
When shall we list now for further hearing?
My lord, 22nd, if it's possible, my lord. Otherwise, I request after 5th of August, my lord.
22nd not possible.
After 5th, my lord.
After 5th.
Yes. 6th, 7th, whatever day, 7th or 8th.
7th August.
7th August. Very
My lord,
well.
with my lord's kind permission, my lord, in the next matter, serial number 6, my lord. Can I seek a short accommodation? I have some personal inconvenience.
Take the.
I'll.
Lords.
Please.
Lords, it's
Okay.
11th August.
Lordships kind leave, my lord. Serial number 68 and 69 in the final hearing matter, their learned senior counsel is.
That is only a direction to prepare a merit. At the time of admission, it was understood from disposal. Some early date. The mandamus is only to prepare a merit list. 68 and 69.
68, 69.
Merit list for? Merit list for the post of deputy registrar
and section.
in the Sanskrit University. Deputy registrar.
Deputy registrar.
Where? Post of deputy registrar in Sanskrit University. Sanskrit in Sanskrit University. Only there. Who is opposing it? We have informed minutes. That is the only scope.
Matter, is it matter posted for final hearing, my lord?
That's right, but it is only scope of, that is the only controversy, preparing the list.
Okay.
Then we'll keep it on 25th July.
2:30 minutes. Start.
Yes, both, yes.
Both cases, 68, 69.
For the component in the start. Picture is ready, but each time it will be like 5 during the course of the kind of conducting next week. Which one? Serial number 12 and 15.
8th August.
12 and 15 also.
8th August.
Serial number 8 match. I mean 6, serial number
16, who meant 16?
15 minute, 1 5.
One.
12 and 15. Serial number 6 minute. Represent appellant counsel minute.
Give it to the respondent.
Next week, any day.
6.
Please.
13th August.
Please, ma'am.
Yes, madam.
Number 29.
20. Yes.
My senior is out of patience.
29 is contempt, man. Hold it, then 13th August.
Serial number 14, my lord.
14, yes. Why? Senior, you are also senior. Your contempt matter, you can proceed. Easiest matter to conduct. Anyway, 13th August. 13th August. 13th August.
Lord, serial number 37 and 39 minutes. Environmental compensation matters. Environmental compensation matters.
Third.
Minutes
Ah,
of-
wait for that.
Yes.
1st August.
37 and 39.
Till number 1.
To respondent number 8 in this matter, my lordship. Same
On
order
this-
can be passed, my
On
lord.
the same line, we'll pass the order.
Yes, my lordship.
It is disposed of for interim order.
Interim
It's
order,
an
my lord.
interim order.
We'll pass on the same lines. Mr. Ramesh, we pass.
Please. Much obliged, my lordship.
You the, write down the appearance.
For dictation.
List 1, seal number 71.
Let us appear for the appellant minutes. This is a case filed by the writ petitioner. Hey, please, minutes. This is a case filed by the writ petitioner without any legal right, without the respondent coming under the purview of Article 12, seeking a waiver of interest rate and reduction to 1.17% per annum. The case was filed when the whole country was in the middle of COVID pandemic, and the learned single judge, considering the situation of the writ petitioner, has granted a conditional indulgence of stay of auction that need to be held on the next day, on a condition that condition, my lords, can see in page number 17 of my writ appeal, my lords. It's in page number 5 of the order passed by the learned single judge. May I read it for my lordship, my lords? May I please, my lords? May I please, my lords? May I please?
You can proceed. Yes.
My lords, the learned single judge on 9/2/2022, considering the limited situation at that point of time, in page number 17 of my writ appeal, has passed an interim order of stay of auction that need to be held on the next day, 10/2/2022, on certain conditions, my lords. The conditions are that the 10% within 2 weeks, next 10% within next 2 weeks, and the remaining 5% within the next 7 days. The learned single judge has very clearly pointed out that if the conditions are not complied, the interim order stands rescinded, but the writ petition itself runs at the risk of being rejected. That being the case, my lords, may I please, my lords? My lords, that being the case, It was already raised, my lords. I filed my statement of objection. It was raised also. In fact, the learned single judge was considered that also in paragraph number. My lords, page number 30, my lords. In page 18 of the judgment. The petition merited entertaining notwithstanding the fact that the respondent is a private financer and would not completely answer its status as being a state under Article 12 of the Constitution of India, who performs the public functions and
Where you are reading?
my lords, in page 30, my lords, in running with the
Page
para-
304.
writ appeal.
Read out.
Page 18 of the judgment, my lord.
So you are
Page-
aware. You are aware about that aspect.
Yes,
Good.
my lord, that
Where is that?
regarding the maintainability of the petition itself was argued for 1 day, my lord. It is a private
It was
finance.
past petition entertainment, notwithstanding the fact that it is that.
My lord, it was during COVID pandemic, my lord, the national policy was announced. And even DRT was closed, my lord, at that point of time. And therefore, this honorable court took up the writ petition and granted the stay based on the COVID pandemic, my lord. My lord, the agreed rate of interest was 1.17%, my lord. I had taken 3 gold loans, my lord. One was 15 lakhs, another was 4,65,000, another was 4,05,000, my lord. Total together, I was paying 27,000 as the EMI, my lord. And the national policy was announced for first 3 months moratorium period. Another 3 months was extended by the Supreme Court. Total together, there was 6 months of moratorium period, my lord. After that, since I was a senior citizen and I suffer from hemolysis of blood, my lord, so I was not allowed to go out of the house. So after that, and when I went to the banker is demanding 2.78% interest and charged me instead of 1,57,000, he has demanded 3,58,000, my lord. And at that point of time, I gave a representation to take only the agreed rate of interest, since I am entitled for the national policy, my lord, the benefit of national policy and senior citizen, my lord. But they did not give any answer. They issued the action notice within 8 months, my lord. And therefore, with no other option, I approached the regional office, I approached the head office, etc., my lord, through mail. I went to the banker so many times, still they did not respond, my lord. And they issued an auction notice. I gave a suitable reply also. For that also, the advocate did not answer, my lord. Therefore, I approached this honorable court. The honorable court granted the stay on 9/2/22, my lord. The action was supposed to be held on 10/2/22, my lord. Immediately, I intimated the banker. I went to the banker and intimated the same thing, my lord. And then after that, they did not even file objections before this honorable court, my lord. For 6-7 months, they did not file even the objections, my lord. Thereafter, they have sold in the force of the stay. They have sold the property, the property on 30/6/2022, my lord. They have not even intimated the court. They have not even filed an application to vacate the stay, my lord. And therefore, the honorable court said, you pay the gold or deposit the market value, pay the market value of the gold. That was the order passed by this honorable court. Since they said it found that there is verge of contempt in the teeth of the interim order, they have sold the property, my lord. And also, the action purchaser was impleaded. He did not come before the court, and they admitted that they have already melted the gold, my lord. And therefore, the honorable court said, you have to pay the market value of the gold or the gold, whatever it was pledged in terms of grams, quality and quantity, my lord.
Auction is held.
My lords,
Auction is held.
auction is held on
36/22, my lord.
36/2022. As per the interim order, the petition has to deposit the amount by 15/3/2022. She has not deposited the money. by the way of the the interim order itself, the learned single judge made clear that if the condition is not satisfied, the order stands resigned. Not only that, the writ petition itself will runs at the risk of being rejected. It is clearly held in page number 18, my lords, 18 of the writ appeal. The top portion, my lords. Admittedly, no amount has been paid by that time. Thereafter, on 4/4, the writ petitioner approached us and paid an amount of 4,18,000 in account that is connected to another writ petition. She had released the gold ornaments. Even otherwise, my lords, in other two writ petition, she had not paid any single rupee till date. My lord, the learned single judge order itself is clear that when the order is not satisfied, there is no interim protection left with the writ petitioner, and there is nothing bars, my lords. And moreover, my lord, thereafter, after the granting of interim order, the petition was again listed before the learned single judge on 10/3/2022. At that day itself, the notice process was being taken. She was liable to deposit 2 installments. No submission was been made to that effect. Again, my lord, the petition was listed only in the month of August.
My lord, 1 minute, my lord, my submission may be taken, my lord. At page 15, my lord, of the judgment, my lord, the honorable judge passes the order like this, my lord. There was a common order passed for all the 3 action notices, my lord. And I was supposed to pay 25%, my lord. I paid 25% of the amount, my lord. They did not take into 3 accounts, my lord. They said they do not have a policy of taking that one into 3 loan accounts. So we cannot take it. They refunded back an amount, that amount, my lord, 1,17,000. They refunded, my lord. Again, I went and paid 4,18,000, my lord. They did not take into account 3 accounts, my lord. They took into 1 account and closed 1 account, my lord. And therefore, the honorable court said, as all the 3 writ petitions were connected, my lord, at page 15, my lord, my lord, at page 15, my lord, the honorable single learned judge passes like this, my lord. As all the 3 writ petitions were connected on the same date, on 9/2/22, and was communicated to the respondent. Therefore, in blatant breach of the interim order that was granted by this court, action appears to have taken place on 30/6/22, despite the petitioner depositing 90% of the amount as was directed by this court. If 10% was remaining, the respondent could have approached this court seeking vacation of the interim order and not put the gold to action contrary to the interim order. Therefore, it is for Muthoot Finance to come before this court and produce a timeline in which the gold or value of the gold that has been put to action in the teeth and contrary to the interim order be returned or refunded. The timeline should be placed in next 2 weeks. And with that, the documents were called, my lord.
Was in the face of record. My lord, what was happened is that the submission
One
of the.
minute, sir, I will just advance my arguments. At page 17, my lord, in the statement of objection, they themselves have written, my lord, it is quoted here. At para 5, page 17, my lord, the respondent respectfully submits that in the statement of objections, my lord, the respondent respectfully submits that even assuming 4,18,107 was paid in the partial full payment of the interim order, does not satisfy the conditions imposed by the interim order dated 9/2/22 on two accounts. Firstly, the amount is much less than the sum of 4,62,478. And secondly, it was paid on 4/4/22, which is much later than the period specified in the interim order. That is the contention taken by them, my lord. For 4,62,000, she has paid 4,18,000. That is why, and that too on 4/4/22. Therefore, it will not satisfy the interim order as written, my lord. For that, the Honorable Court says, the quoted paragraph, the statement of objection would indicate that the interim order was complied with on 4/4/22, which is much beyond the period that was stipulated in the interim order dated 9/2/22. But the action was not taken place then. The action takes place on 30/6/22. Therefore, when the interim order was granted and substantial payment was made by the petitioner, the financier could have not sold the pledged articles in action. Since on this fact, the financier has acted contrary to the interim order, the petition merited entertainment, notwithstanding the fact that the respondent is a private financier and would not completely answer its status as being a state under Article 12 of the Constitution of India, who performs public functions, and loan is granted under the statutory requirement as enunciated by Reserve Bank of India. On all these factors, the petitions are entertained and the amount of 24,39,085 is deposited before this court. That amount was deposited, that is the action amount, my lord, 24 lakhs, which was much lesser than the market value, my lord. The pledged gold was 618 grams, my lord. The value itself was 42 lakhs, my lord. The deposited amount is 24,39,000, my lord. And therefore, the Honorable Court said, the proceeds of action and documents of the action are all placed before this court. Therefore, the petitioner becomes entitled to deposit that is made before this court of all the gold articles, reserving liberty to the petitioner and without prejudice to knock at the appropriate fora for appropriate relief for any remainder of the amount. The registrar of the court shall forthwith release the amount in favor of the petitioner that is deposited before this court, my lord. My lord, there was a direction to pay the market value, my lord, but they deposited the action amount of 24 lakhs, my lord, which is much shorter than even the market value of the gold, my lord. My lord, the loan given by them is only 50% against 100% security, my lord. If I take loan for 100 grams, they give loan for only 50 grams, my lord. First, out of 100 grams, they will take out all the stones, my lord, precious stones. That will come to 80 grams. Thereafter, they give 70% of 80 grams. That is called as 9.16%, they say, and they give loan for that, my lord. After that, if the market value of the gold is 6,000, they give only 75% of the market value, my lord. Total together for 100 grams of gold, they give, if it is 6,000 or 65,000, they give 30,000, my lord. And that is how, for my 618 grams of gold, total together, they have given just 23 lakhs, my lord. Just 23 lakhs, my lord. Even without any making charge, even without any wastage, even without any GST taken into account, the Honorable Court was lenient for them to deposit the market value, my lord, which they did not do it, my lord. In fact, during the argument, my lord, the Honorable Single Learned Judge said, the reserve of Muthoot Finance is more than the reserve, gold reserve of Pakistan, my lord. It is more than the reserve of Pakistan, my lord, because they take 100 grams gold and give for 30 grams of gold, they give the loan, my lord. Because the interest they give more, this thing, we have taken it for my purpose, and that too, my daughter is physically disabled. For construction purpose, I had taken, my lord. And during that time, I fell ill and developed hemolysis of blood, my lord. And therefore, during COVID, I was not able to pay for 6 months, my lord. Immediately, I went to the banker, my lord. They said, this thing has grown up to so much. I was gabrified, my lord.
We'll pass some order on Wednesday.
My lord,
My lord, one submission, my lord. Section 23 of the Contract Act, my lord, it comes under Contract Act also. There is violation, there is dignity of human dignity violation is there, my lord. I am a senior citizen. I was made to move from pillar to post. Second thing is Section 23 of the Contract Act says, anything they do unlawful, anything, even if they fully knowing well that they have to refund or return back the articles, they have not returned back, my lord, even after paying the amount. Therefore, I pray this honorable court that it is unlawful whatever they have done and illegal, and therefore they have to be penalized, my lord.
My lords, I'm passing over 2 citations.
And I have produced the authorities of action wherein when there is a stay is granted or the injunction is granted, if they act in violation of that, even the Supreme Court and the Honorable High Court has awarded punishment for them in the penalty form of money and also in form of imprisonment, my lord. I am not requested so much, my lord. I am not great so much to pray this honorable court. I come to the temple of justice. I need justice, my lord. And that too, I've got emotional attachment to that. My husband had given and my mother-in-law had given, my lord, one bangle with diamond, my lord, that they have taken all the diamond, my lord, and they have not given, my lord. Diamond was there and pearls, all things, but they did not give, my lord.
My lords,
They
admittedly,
have not given loan for that. Neither after melting, they have not given that also, my lord.
this is exactly what happened before the learned single judge also, my lords. The party in person is continuously making submission, not permitting us to make out our case.
You please permit,
Admittedly,
you can
please.
permit, I'm not.
It is admitted fact that loan is taken, loan is defaulted, interim order has been granted, interim order has been violated. All this has been admitted fact. It is an error in the face of the record that the interim order is violated. There is a contempt. And if that is the case, my lords, if there is for the XYZ reasons, the petition required some more reasons. It is for the petitioner to approach this honorable court and by filing extend the time, my lords. It is for them. Admittedly, my lords, at that point of time when the matter was the auction was conducted, there was no order is in force.
Wednesday,
Thank you.
23rd.
Grateful, my lords.
List one, cell number 7. Dhanlakshmi, why?
May it please, Your Lordship. My lords, there is this writ petition is, writ appeal is by a person who was not party before the learned single judge, my lords. There is a delay of 625 days. And BDA has also filed an appeal. I'm given to understand, my lords. It's WA 820.
Both will place together.
883 of 2022 is there, my lords. 883 of 2022. And that is before the learned.
Bill number 883.
My lord, that writ appeal is before Court Hall 2, my lords. It's coming on 22/7 because it was 2022 matter. What happened, my lords? What happened, my lords? After the learned single judge's order, after 1.5 years, they sell it to me for 10.5 crore rupees.
You better,
despite there being an order. Now the matter is before the court hall 2, my lords. That WA and this WA may have to, that's where I'm requesting this honorable court to
for
kindly.
you to file, if you want to club two matters together, then you file a note before the registrar. File a kind of note to the registrar judicial. If you want both the appeals to be taken together. If you want to proceed here, we'll conduct them. Your choice.
That would lead to different, this one, my lords, because BDA has also challenged, we have also challenged, and in between there is an order which is violated by the BDA, and despite there being a order, they have sold the property to me for 10.5 crore rupees. And now I am in a fix.
File some.
We will
note
file,
before the registrar.
please, my lords.
Yes. For the time being, we are keeping this on 30th.
22nd is there. Can we have it day after tomorrow, my lords? I'll try to.
Day after.
Please, my lords. Tomorrow, Monday, my lords. Please.
It's number 8. Anand KR.
If the appellant, what matter relates to interference by the learned single judge with an order of the labor court law. The labor court law did not accept the finding of the inquiry authority. My lord, the allegation was one of theft. My lord. On 6th of March 2007, the employee concerned, my lord, was searched when he was leaving the factory, and he had concealed some copper wires, and he was charge sheeted. And my lord, an inquiry report was given at page 54. My lord, the submission that I'm making, my lord, is that when the inquiry officer, domestic inquiry, evidence is taken, and a very elaborate discussion takes place on the evidence, and a finding is recorded that he was caught with this stolen material. The labor court, my lord, on a challenge, considers two aspects first, as to whether the inquiry was fair and proper, and thereafter, my lord, it considers and practically revisits the entire evidence and comes to the conclusion that the inquiry officer was wrong in the conclusion he reached. My lord, the law on the point is quite well settled that when there is some evidence and there's a balance of probabilities, the labor court cannot interfere. Now, your lordships may please turn to page 54. That is, these are the findings, my lord, of the inquiry officer on evidence. The report begins at page 54. Kindly go to page 80, my lord. The discussion is there on this aspect. Para C. From the above, it is clear that Mr. Shivkumar had come for duty on 6307 for second shift. Shivkumar, my lord, is the delinquent employee. While going home at the end of the shift, the security personnel found him carrying copper pieces belonging to the company hidden in the apron provided to him, which he was carrying in a bundled manner, keeping it below his right-hand shoulder, for which he had no authority. Then, my lord, next para, I'll skip, my lord, the following para. On 13/7, charge sheet was served on Shivkumar, fully detailing and describing the charges. He was called upon to file explanation when the inquiry opens. Then, my lord,
Violation notice.
Notices. The interim order, my lord, I have sought, because otherwise there's a direction to pay 25% back wages. Case of theft, my lord. He is now retired, superannuated.
He is retired.
He has retired now.
That contempt is filed. Contempt is filed.
No contempt is filed yet.
That is the 8th of August. Notice it.
Please.
K. Krishna.
If I respond, number 125. That's the challenge, the order, the learned single judge. Insofar as the preliminary notification dated 25/11/2002 and final notification dated 11/5/2004 are quashed. I'm appealing for the metro rail. I am a beneficiary of a smaller extent of land which was covered by these two notifications. As I'm told, my lords, that the acquiring agency, the KIADB, has also filed writ appeals. I'll just hand over the writ appeal numbers to the court officer. Now, in the meantime, my limited submission for today is this.
I appeal respond number 1 to 4 minutes, 1 to 5 minutes. My lord, other writ appeals.
I only have a limited submission to make.
Four writ
Have to
appeals
be heard.
are
It will have to be heard along with the other writ appeals, no doubt. During the pendency of the writ petition before the learned single judge, there was an interim order passed which ordered a status quo but permitted the metro rail to continue doing its work in light of the fact that this is the all-important airport line which connects. The land is near Hebbal. Finally, the learned single judge allowed the writ petitions, quashed the preliminary and final notifications, but made one observation, which assumes importance. My lords, may kindly see page 35. Page 35, paragraph 14, my lords. In the light of the judgments of the division bench and having regard to the fact that the awards have not been passed for nearly 14 years from the date of dismissal of the petition, the acquisition proceedings cannot be sustained. Consequently, the notifications dated so-and-so, insofar as the petitioner's lands are concerned, is quashed. Now, I rely on paragraphs 15 and 17, my lords. The learned senior counsel on instructions from petition number 2, who is present in the court, submits that in respect of the portion of a land belonging to the petitioner number 1 and 2 have been earmarked for use by the BMRCL, and he submits that the petitioners are ready to hand over the land provided the package compensation offered by the BMRCL is offered to them. This statement is placed on record. The learned counsel for BMRCL submits that the compensation amount in respect of the lands needed for BMRCL has been deposited with the KIADB. If the KIADB is prepared to pay the said package amount to the petitioners, the statement of the petitioner that they would hand over possession of the land, which is earmarked for use by BMRCL, is placed on record. My limited submission for today is this. Of course, your lordships may have to consider the larger aspect as to whether learned single judge was right in quashing the notifications. But in light of the undertaking given by the learned counsel for the writ petitioners and the fact that BMRCL has already deposited the amounts with the KIDB, whichever way your lordships were to eventually hold, if my lords were to dismiss the writ appeals, even then, this undertaking would bind them. If my lords were to allow the writ appeals, then these lands, obviously the acquisitions would be upheld. So therefore, my limited request is this, my lords, could the BMRCL be permitted to carry on with its work? Because that was what the interim order also permitted us to do before the learned single judge. There's an important line, my lords, which connects to the airport. So that's my limited request. On the larger issue, my lords, certainly the acquiring agency would have to defend its actions.
Yes, no compensation is paid, my lord. Nearly 14 years are over. They have deposited the compensation with KDB. If they gave us the compensation money, we have no difficulty. We will not object to it.
Yes, but we have deposited with the Karnataka Industrial Area Development Board. Now,
Right now,
the submission is, whatever the fate of these writ appeals, eventually, my lords, these.
So they are interested in compensation only.
I'm sorry.
In this particular metro acquisition, we have made a statement that if the KADB makes payment to us, so far as the land in occupy metro wants to do work, we have no objection. But they should agree to pay us the compensation, which they are deposited with KADB.
They have deposited with the KIDB, my lord. So therefore, my limited submission is this. Eventually, if my lords were to dismiss these writ appeals, subject to, of course, them filing an appeal before the Honorable Supreme Court, that amount will have to be released. From our end, my lords, we've already released the amounts. So therefore, my lords, if we could be permitted to carry on the work, because if we succeed in these writ petitions, in these writ appeals, my lords, the learned single judge's order would have to be set aside.
Where is the amount? Like,
With
With the
KID.
KIDB, with the Industrial Area Development Board. They have also filed writ appeals.
they can withdraw it.
Well, I don't have authority to make that
Lordship
submission.
permits, my lord, we will withdraw. So KIDB should be ready to give it to us.
We have filed the writ appeal against the same order, my lord. We have filed the writ appeal against the same order.
Very well. They could be all
14
taken
years.
together also. A short date could be given. I understand Mr. Arnaldi's difficulty also.
14 years are over, my lord. No award, no compensation. We are virtual.
File appeal. My lord, why you have filed appeal? It was stated that the KIEB has filed cross appeal in respect of the very order brought under challenge in this appeal. Therefore, this writ appeal should be listed, may be listed with writ appeal number so and so.
Could the delay be condoned? What is the 3-day delay in preparing the appeal?
Delay will condone. All are appearing.
Yeah.
Or learned the parties. We have 23 days. 3 days.
3 days.
3 days.
Delay of 3 days condoned as sufficient is made out from the governments made in the supporting it.
Subject to your lordship's convenience, the earliest possible date. I want, only because the work is stalled right now, because finally, we have to reach the airport. So in the middle, if there's some work that is stalled.
2nd August.
Obliged. 2nd August.
Number 10. Complaints and contempt matters.
I pay for the complaint, no. I pay for the complaint, no. I need a short accommodation, no.
The compliance affidavit has been filed.
Compliance.
Compliance.
I pay for the complaint.
My lords.
Mr. Counsel,
don't-
compliance affidavit is filed.
11th November, 2023.
No, compliance up to it, but I need a short accommodation, but
Why?
Because there was an order.
The order is not
from
fully
the
compliant,
judge,
it's only
my lords,
partly
to
compliant.
Do the public road, my lords, that has been done. You consider the representation and the representation has been considered. Page number 4, 5, 6 states, my lords.
Kindly
where
look
it is
into
a
the order of the
public
learned
road.
single judgment, page number, para number.
Why do you need time, Mr.? Asphalt road is already.
It's been done, my lords. So page
Link-
number 4,
link.
5, 6 reads where it shows the asphalting is reason.
The road is not
Where
fully
there is a
completed, my lord.
dispute, my lords.
Only half road is completed.
Yes.
Kindly look into page number 17.
Where there is a dispute, my lords, we have not done. Before the learned single judge also, we have made the statement. If it is a public road, my lords, we will do that.
We dispose of the matter. It is complied with.
No, it's not compliant, it's only order of the learned single judges. May kindly look into para number, page number
Alright.
17, my lord.
Tomorrow?
Yes, ma'am.
Tomorrow at 2:30.
Yes, my lord.
Question number 11. B. Vidulata.
Lords, writ appeal has been filed in the morning, my lords. We have received the FR number.
It's connected, my lords. It's handing over possession of our lands, my lords. Our sites within 2 weeks from the date of the order. They've not done so. If the writ appeal is connected, the Tahsildar, my lords, had no jurisdiction to even take away our sites, my lords. Under no provision of law, he can take away sites, my lords. That's the observation of the learned single judge. Without any inquiry, without serving notices to us, my lords, he comes and demolishes and takes away the land belonging to us, my lords, claiming it to be a government land. It has to be done in accordance with law.
Writ appeal has been filed in the morning, my lords. We have received a FR number.
To be listed with writ appeal. Number
FR number 1063 of 2024.
on 1st August.
My lords, till fifth, I'm not in state.
Fifth.
After fifth, any date.
After 5th. 7th.
Grateful.
Well, urgent, seal number 13. Mr. Vaishali Hegde.
Its compliance affidavit has been filed, my lords. The representation has been considered.
But looking to that compliance affidavit, your lordships had given them time. Please see on the last occasion, your lordships gave them time. They had filed the affidavit on 9/5/2024. Matter had come up on 18/6. Matter was heard and again they took time. Annexure R5, my lords. In fact, this is a case where the measurement survey has to be conducted for our lands. Now they say all the original records are missing. Then they say we are going to create records, but they also admit that we are in possession. They had attempted to conduct the survey to demarcate our land in 1978. After that, they have not done. Looking into the compliance affidavit itself, your lordships had given them time. 13. ಯಾವ್ದು ಇಟ್ಕೊಂಡಿದ್ದೀವಿ?
Lords, Lords, in serial number 13, my lords, now we have issued the Sagwali chit, my lords. The Tashildar has issued the Sagwali chit. May I pass on an intimation for issuance of Sagwali chit has been issued to the complainant, my lords. Once they pay the amount that has been notified, intimated to them, my lords, the Podi and Durasti process will be conducted.
They're demanding 3,225 my lords for, we don't mind paying it tomorrow or today itself, if that is the case.
Let's let them collect the Sagwali chit. Their records were not in place.
That
Now
is
the
not-
records have been built, my lords, in their favor.
Then you challenge this independent.
My lords, all that your lordships had seen that, lords, they say that records are missing. They have to build the records. I can't
We
build the
have built
record.
the records is what I'm
Then they have to
submitting.
carry out the Podi exercise. That's all what remains.
Now we have built the records, my lords. We have issued them the intimation slip to
You
give it.
recreated the record or not?
My lords, we have, once they pay this amount, my lords, the Sagwali chit, which is the basic document for grant, will be issued to them. Thereafter, the Tashildar will conduct this 1 to 5, and then the DDLR will conduct the 6 to 10, my lords. This is the process, my lords, that we have followed.
The order of the learned single judge was passed. Please see at page 18, my lords. This was way back in September 23.
These are the prescribed fees.
My lords,
The order mentions about payment of the fees.
payment of, my lords, they now want us to pay 3,225 rupees. That they are just giving it. But we, my lords, we will pay it, but there should be, the learned single judge had ordered, my lords, within 12 weeks. Now, my lords, again, they keep it open-ended that they want us to again go back to them.
Lords, the records are required for conducting Podi and Durasti. In the light of that, now, my lords, the records have been built, my lords, and we have issued the intimation slip to pay this amount so that they will collect the Saguali
The
check.
order of learned single judge dated 20th September 23, passed in writ petition number 19647 of 23. The respondents were directed to conduct Podi, Durasti within a period of 12 weeks. The prayer of the petitioner in the petition was to carry out the Podi and Durasti in respect of survey number 90. Within 2 acres of land, 2 acres and 2 meters, 20 gutas. Situated at Yella Dahali, Madur Taluk, CA Kere, Public, India District. When the petition came up for consideration, learned additional government did promote unification. Gives copy of order dated
Official memo.
1/24. It was explained that by the side order, it was explained to the court that by translating, by orally translating, it was explained to the court that in the side order, the competent authority has ordered it 16/7. The side order, the competent authority is required payment of certain fees totaling ₹3,225 for conducting the Podi and Durasti. Learned advocate, learned senior advocate, Mr. Anindra, stated that while the applicant will be paying the said amount,
That's not actually, they have not asked it for Podi and Durasti.
duty, the obligation is not discharged by, the obligation to conduct the Podi and Durasti is not discharged by the authorities despite passage of the specified times as provided for by law in a single judge. Full stop. Any of the above development that the petitioner, that the respondent authority have acted themselves to proceed to conduct Podi and Durasti as reflected in the aforesaid order, comma, the present contempt proceedings are disposed of by directing the respondents to conduct the Podi and Durasti proceedings within a period of 6 weeks from the date the amount is paid by the complainant. Post of failure on part of the respondents to comply with the directions of law in a single judge as well as the directions in the present order shall expose them to aggravated form of contempt.
Please.
May I pray for 8 weeks' time?
8 weeks.
Obliged.
14, 15 are adjourned. Syllabus 16.
Appear for control respond.
For the appellant, madam.
In this case, where my lord,
For the appellants.
Okay,
Madam.
you are for appellant.
Yes, madam.
So what are you passing?
notification of award is issued to me. The appellant, my lord, invited tender on 27/10/21 for 3 items. ICU cots, portable X-ray machine, my lord, syringe pumps. Lord, bid took place. Then, my lord, technical lord, bid I passed. Financial bid I passed. Notification was Award was passed on 2/3/22. Annexure G, page 207. Asking me to pay the security performance, which I have paid. Lord, thereafter, Lord, they have not issued a purchase order. I approached the court. But the Learned Single Judge, examining the Lord cause, allowed the writ petition, directed the Lord the appellant herein to issue purchase order. Under that order, Lord, the filed appeal.
File translation of this.
Lord, it has no connection. Lord. That document has no connection with the appeal at all. I have invested 10 crores, my Lord. My Lord will remember.
File
When I made a submission last
File
week.
translation of the document. English.
Proxy counsel. Proxy counsel.
Pardon?
Proxy counsel, my lords.
Could you file translation? Translation you can file. Proxy or no proxy?
Yeah, I make an appeal to your Lordship. That document has nothing to do with this appeal.
Proxy.
The government order dated 27/12/20. But the 21, my Lord, tender.
Proxy counsel will not conduct the matter. They will file translation.
Not difficulty, not for me, my Lord, I have difficulty, but there's stay order. My Lord.
Counsel will
We'll
get
take
in
up.
the-
And 10 crores I have invested. In fact, I
26.
mentioned to your Lordship last occasion. They said
Counsel.
they will be arguing today.
Lordship,
I appear for the appellant in this matter, Lordship.
counsel is in the video.
Counsel, both counsel not first. 26th you file translation.
Just for the
Please, Lordship.
submission of the documents, I appeared, my lord. Just for the
Please,
submission of
Lordship,
the.
I'll submit the translated copy, Lordship.
But we are telling you to file translation. Convey to your senior counsel. The
Please,
translation is required.
May I make an humble appeal to your Lordship? That document has nothing to do. I've seen that document.
So you want to see how it is nothing to do.
I will explain to your Lordship. Because of my difficulties, my Lord. When I mentioned to you last occasion, my Lord said
Next week, 26th.
at 2:30, Lord. Otherwise, the difficulties, Lord. The tender is, Lord, notice award is awarded to me. I invested, Lord, 10 crores.
On 26th, we will let us.
At 2:30, Lord. May I? Last occasion I mentioned to you, Lord, it is posted today.
Today it is reached to
It reached, Lord, it's my fortune.
2:30.
My Lord is no doubt about it. I only humble appeal is, my Lord, my difficulty is appellant, respondent one, my Lord, put to hardship. Otherwise, I would have not made
2:30.
Number 17.
any
Been raised
specific
here.
time, my Lord, 2:30. There's a difficulty I face. I humble.
2:30. But in
Yes.
But in this matter, I'm making an I may be permitted to make an application for appointment of a commissioner to see, commissioner, the assistant
Not
director
arise
of
at
land
all.
records to come and see, just making the.
If your lordship recollects, my lords, the preliminary notification is of the year 89. Award is passed in the year 1990. Lords, and compensation was received by mother of the
No,
petitioner.
no, all the points I am going to meet, let him not be hurried.
In this
My lord,
department,
here is a case.
And
where
similar matters, my lord, Supreme Court has already.
That is on different point.
Heard
This
the
is on the
accusation.
point under section 24, subsection 2 of the new act, as the accusation has been lapsed. We have filed a writ petition seeking declaration that the acquisition proceedings have been lapsed by virtue of section 24(2) of the new act. The land is still barren, no roads, no sites have been formed. Just let the commissioner be appointed in this case to go over see the land, whether it is developed or not.
Your lordship may recollect, my lords. They are arguing on the count of application of section 24(2) of the new act, Right to Fair Compensation Act.
Sites are allotted.
My lords,
Sites are allotted.
sites are allocated for that, to meet.
No formation of layout. I can demonstrate before your lordships that the entire land is barren, it is vacant, it is in our possession. That's why let the commissioner be appointed, let him come and submit the
Only
report
one-
about the situation of the land. I have demonstrated in the last occasion by taking the Google photograph.
Last occasion we have forgotten. Now demonstrate.
Lord, I have the Google photographs which show. Your lordship
But
may
this
kindly-
very petitioner, my lord, has executed a confirmation deed.
That I have executed, I have taken consideration and executed.
This very.
Lord, I'm making the application, I have served the copy and then.
Application you can submit.
Lord, get this application.
Your lord,
considered.
my lords, this very petitioner, my lord, has executed
I'm
a
just
confirmation deed.
Seeking the
in
appointment
favor
of a commissioner
successor from
to
allotting.
go over to the land in question and inspect the spot, whether any sites are formed, layout is there, whether what is the nature of the land. I can demonstrate before this honorable court with this photograph that the land is bare.
What you brought? Photographs?
Yes, Google photograph.
Satellite photograph?
Yes,
It's like this. Serving copies, I don't know what. ಇದೇನ್ ಸರ್ ಮೆಮೊ ಇಲ್ಲ ಏನಿಲ್ಲ.
Yes.
Lord, if this property is not at all developed, it is as it is. We are in possession because by virtue of a judgment and decree passed in the civil court, the possession continued with the landowners. Lord, two aspects are there. First, the possession is not taken in the eye of law. The second, the compensation is not paid. No award is passed in the eye of law. So the acquisition itself been lapsed by virtue of section 24, subsection 2 of the new act. I can demonstrate.
The very same notification was called in question, my lords, by the other landowners. The matter
It is
reached
on
up
a
to Supreme
different
Court.
point, not under section
Acquisition has
24,
been-
subsection 2. The
Acquisition
earlier
has been
petitions
upheld.
filed by
Petitions
some
have
other
been
people
dismissed.
that they have challenged the acquisition notifications,
sure.
but not on the
Page
ground of
1089.
lapsing of the acquisition.
That's-
Before this
Your
matter
lordship,
could
can
be
you see
heard,
volume
let
3,
this
page
commissioner be
1089.
appointed, submit the report about the existing scenario of the land in question, then the matter can be heard.
Volume 3, my lords, page 1089. The division bench judgment, my lords, in respect of very same acquisition. This very appellant, my lords, who is the petitioner, has executed confirmation deed in favor of an allotee of the society in whose favor the acquisition is there. Once, my lord, there is a confirmation deed executed by the petitioner. How can he canvass, my lords, that possession has not been taken? My lords? That ends there. And my lords, for application of indoor development case, now as per the judgment of the Supreme Court in indoor development, twin criteria have to be met. Both award should not be passed and possession should not be taken. My lords, here is a case where award is also passed. The mother of the petitioner has taken 50,000 rupees way back in the year 1990. That is the consent award. In 2000, my lords, till 2000, this mother of the petitioner do not initiate any action. In 2000, my lord, the petitioner along with his brothers creates a partition deed and says that in the partition deed, this property fell to his share. And instead of filing writ petition, he files a civil suit. That suit, my lords, he was litigating in the suit till 2015. 2015, he files this present writ petition. While filing the writ petition, my lord, the ground which was canvassed is consent award is passed after 1 year. Therefore, there is violation of section 11 of the Land Acquisition Act. That was the primary ground which was urged in the writ petition. In the year 2023, my lords, after we file our objections that no consent award is passed within the time, well within the time contemplated under law, he makes an application for amendment to call in question in the year 2023, alleging the consent award has been passed by way of fraud. In the year 2023, for the first time, he raises the ground of fraud in the year 2023. The learned single judge, my lord, after taking note of all these things, said, my lords, this petition should be dismissed on the sole ground of delay and laches. Your lordship may also consider the fact that this very petitioner has executed a confirmation deed in favor of an allotee from the society. And so far as acquisition in favor of this society, my lords, other landowners had challenged. The matter reached up to Supreme Court. Supreme Court has also rejected the SLP. And one of the coordinate bench judgment, my lords, is Annexure R4, volume 3, page 1089. This very ground of fraud was alleged. Para 5 of that judgment, my lord, which your lordship will get at page 1093. When, my lords, when the mother of the petitioner did not challenge the consent award for 10 long years during her lifetime, how can petitioner, my lord, all of a sudden 2000 come to the court? Not even in 2000 also, that was not his case, that this award is not passed. His case was that in 2015, award is passed beyond 1 year. I can point out from the memorandum of writ petition. That was his ground. In 2023, for the first time, he is alleging that the consent award is fraudulently passed. At what point of time this can be raised is the question, my lords, before your lordship. And moreover, to apply 24(2).
Each and every point I can meet him, Lord. The ground on which this writ petition is filed is that the land acquisition proceedings have been lapsed by virtue of operation of section 24(2) of the Land Acquisition Act. For the simple reason, my lord, that the possession remained with the landowners. It continued to be with even now. No developmental activities have been done in the land in question, except in one case where the confirmation deed was executed in favor of one allotee. For consideration it was given. So we have taken consideration and given up our rights. So just because that is there, it doesn't mean that we have accepted. That is one thing. Entire property, as could be seen from the photograph, that entire property is barren, except on the roadside, 1 or 2 sites. They have constructed the building where the confirmation deed is there. So remaining part, entire property is still, it is as it is, barren. That is one thing. Secondly, no panchanama has been drawn for taking the possession, as pointed out by the apex court in indoor development authorities. That is one of the best mode of taking possession. No panchanama, nothing is there. Then secondly, this award is not an award. In fact, the learned single judge, while passing the order, has clearly categorically stated that the award is not passed in the eye of law, because 9 and 10 notices were sent, they were not present. So your lordship kindly take the consent award, which I have produced at page 125 of the paper book, where notices under section 9 and 10 have been issued. What they say is, the secretary of the society has stated that compensation amount 50,000 in respect of land has been paid in advance to the landowner, rupees 49,000 is due to be paid. For 50,000 payment, no record is placed on record. And for depositing or payment of 49,000, no material is placed on record. So that means to say that the compensation is not paid. That's another aspect. Next, another important aspect is section 16(2) notification is made, but Panchanama is not there. So in so many other lands, except this land in survey number 27/1 of Singh-Sundra, all other lands layout has been formed except this property. So that is the reason, my lord, I have made an application for appointment of the commissioner. Let the commissioner go out to the spot land in question. Let him survey and submit the report about the situation of the property so that your lordship could be able to take effective decision in this aspect. That is one. That's the reason why the application is made. So kindly consider the application. So the division bench of our Honorable High Court as well as the apex court categorically have said that if the amount of compensation is paid prior to the notification is no payment, there should be an agreement by the acquiring authority with the landowner. If the agreement is with the beneficiary, it is no agreement. Lord, I'm just placing the reliance on some decisions of the apex court. Lord, before this matter could be heard on merits, my application may be kindly considered.
Everything together,
Please, Lord.
everything together. What is this?
Lord, I'm just placing the list of authorities which I'm relying upon. Your Lordship may kindly take the first judgment, the Indoor Development Authority case, where their lordships have held that the effective mode of taking possession is by drawing Panchanama. Your lordship get it at page 163 of the judgment, para 16 and 17. At page 163, your lordship could see regarding question number 4, mode of taking physical possession under 1894 Act. The mode of taking possession under 1894 Act as contemplated in section 24(2) is by drawing of inquest report or a memorandum. Once the award has been passed on taking possession under section 16 of the 1894 Act, the land vests with the state. There is no divesting provided under subsection section 24(2) of 23 Act. Then, when the state government acquires the land and draws up memorandum of taking possession, that amounts to taking physical possession of the land. And in below that, the drawing of Panchanama in presence of witnesses would constitute a mode of taking possession. One of the accepted modes of taking possession of the acquired land is recording of memorandum or Panchanama by the LAO in presence of witnesses signed by him. That would constitute taking the acquired land. It is the common knowledge that in some cases, the owner interested person may not cooperate in taking the possession of the land. That is, so this is the law laid down by the apex court in Indoor Development Authority case.
Yes.
My lord, the second point which I would like to canvass is next judgment, a full bench judgment of our Honorable High Court. So it 2010 4 Karnataka Lajar, page 19, para page 34, para 17.
Page 30.
34 of the judgment, internal page. Lord, 8 lines below, it is no doubt true. The Lordship got it. It is no doubt true that the Act is silent with regard to the mode of taking possession. It is settled law by the series of judgments of the apex court that one of the accepted modes of taking possession of the acquired land is recording of memorandum or panchanama by the deputy commissioner or the land acquisition officer in presence of the witnesses signed by them that would constitute taking possession of the land as it would be possible to take physical possession of the acquired land. Then in para 18 also on the same point, they say that it is settled law, series of judgments of the apex court that one of the modes of taking possession of the acquired land is recording the memorandum or panchanama by the deputy commissioner. Same point. Lord, the next another important aspect I would like to bring it to your lordship's kind notice is page 57, ink page 57.
57.
Writ Appeal 301 of 2023. Writ Appeal 301 of 2023, Division Bench judgment, dated 27/9/2023, para 20 million. 20. Para 20, page 76. The same thing has been considered. The other contention with regard to the respondent BDA not taking possession of the land by drawing mahazar in a manner known to law and reliance placed on by the learned senior counsel for the appellants on the judgments referred herein before are of no avail in view of the fact situation of the present matter was narrated herein above as rightly taken note of by the learned single judge. The full bench of the court in case of ITA Employees Housing Cooperative Society versus Venkatappa with regard to the modes of taking possession of the acquired lands and also judgment of the apex court in case of Indoor Development Authority, wherein it is held that once panchanama had been drawn, taking possession, thereafter act of re-entry or retaining possession is as that of a trespasser. So here also it is this the concept of taking panchanama, taking possession by drawing panchanama is not there in this case. Another very important aspect I would like to bring it to your lordship's kind consideration is my learned friend was vociferously contending that there was an agreement that landlady has taken 50,000 rupees. So your lordship may kindly come to the next judgment, that is 2009 1 Karnataka Law Journal, page 102, para 16 and 19. Writ Appeal number 159 of 2006. Para 17. By virtue of section 30 of the Act, in respect of the inquiry and award by the Deputy Commissioner, section 11 of the Act becomes applicable to the procedure prescribed therein is required to be followed unless the land has been acquired in terms of section 28(4) of the Act. Law does not provide for any agreement between the state government and the person to be compensated, since without an acquisition of land, the state government or the delegated authority in terms of section 31 has no power to enter into agreement. If it's very, very clear. So the agreement entered into prior to the acquisition proceedings is no agreement. The land can be acquired under chapter 7 of the Act for the purpose of development by the board or for any other purpose. The furtherance of the objects of the board has not been empowered under the Act to purchase the land by an agreement with landowners for the purpose of development or any other purpose in furtherance of the objects of the Act. The mode of acquisition of land for the purpose mentioned in the Act is only having recourse to procedure stipulated under chapter 7 of the Act. It is well settled position of law that when a statute vests certain power in an authority to be exercised in a particular manner, then the said authority exercise it only in the manner provided in the statute itself, not not in derogation thereof. When the statute requires a certain thing to be done in a certain manner, it can be done in that manner alone, unless the contrary intention is to be found by the statute. Then kindly come to para 19 of the same, para 19. Para 19. Lord, respondents 2 to 5 had submitted the representation dated so and so with regard to the injustice suffered in the matter of payment of compensation, land acquired, reply were so and so. The learned single judge, noticing the fact that the agreement could not have been entered into prior to the acquisition of land by issue of notification under section 28(4) of the Act, the agreement is no agreement in the eye of law. Consequently, the stand taken in Annexure J is untenable. As quashed the same, we have perused Annexure J, from which it is clear appellant contends that in view of the payment made on the basis of the agreement in terms of section 29(2) of the Act, in view of the delivery of possession, the claim was disallowed. In view of our findings on the points 1 and 3, supra, the learned single judge is justified in quashing Annexure J, that is acquisition proceedings. Lord, the payment made in the absence of even making of an award cannot be called as payment towards acquisition of land. Now, before passing the award, payment is made. Before initiation of the acquisition proceedings, they say that they have entered into agreement. Lord, another judgment on the same point in this reported in ILR 2006 Karnataka 922, my Lord Justice Gopal Gowda has also followed the same thing. The agreement could not have been entered into by the parties before acquisition of lands have become final by declaration of final notification. The rights of the landowners to claim proper market value of the acquired lands cannot be deprived of by the board. So the para 5A of the said judgment makes it very clear at page 92. Page 92, ink page 92, para 5A of ILR 2006 Karnataka. Even though section 29 subsection 2 of the Act states that the compensation shall be paid in accordance with the agreement in view of the fact that the agreement could not have been entered into by the parties before the acquisition of land has become final by declaration of final notification, the rights of the landowners to claim proper market value for the acquired lands cannot be deprived of by the board. In law, they are entitled for just compensation to be determined as provided under the provisions of Land Acquisition Act before compensation amount is paid by agreement to the petitioners, landowners. The deputy commissioner shall determine the market value of the acquired lands as provided in section 11 of the LA Act by taking all relevant aspects as provided in section 23 of the LA Act. So this is the law laid down on this point. Lord, the contention of my friend that 50,000 was paid is no payment.
It was
So-
paid. It was paid or not?
No, it's not paid. Let them produce the material to show that they have paid the payment. Simply they say that we have paid because there is a reference in the consent award. In the consent award at page
I'll pass on the document.
125. It's no payment. Even if it is made, it is no payment. The secretary of
Sorry,
the
my lord, it
society
is in Kannada.
stated that compensation amount of rupees
It has been-
50,000. Lord, 2 acres,
Number,
19.
everything is referred.
Huh? Énidu? But this
At serial number 15.
this
my lord,
cannot
15.
be relied upon.
Munyamma. Munyamma is the landowner for her 50,000 rupees has been done.
Serial number?
Where is
Serial number 15, my lords.
where is the record for showing the payment? If you just
Munyamma.
Type it
Check
and produce
number.
it.
Check number, date, everything is mentioned.
Lord, my humble submission to Lordship is, in view of the
Not
division.
challenge it during your lifetime.
Not necessary for me, because the division bench of this honorable court has taken a clear-cut stand, the apex court has taken a clear-cut stand that if the payment is made prior to the acquisition proceedings are initiated, is no payment. The payment should be made by the acquiring authority. See, the deputy commissioner has to enter into agreement, the deputy commissioner has to pay after passing of the award, not prior to that. So that's the reason, my lord, I just relying upon the judgment of the division bench of this honorable court. Lord, 2009 1 Karnataka Law Journal, this is a division bench judgment, para 16 and 19. It is very, very clear. Agreement could not have been entered into prior to the acquisition of land by issue of notification. So therefore, that cannot be taken into consideration at all. Even if it is there, it is no payment in the AF law.
So last judgment.
Please, ma'am.
This was last judgment. Or
Yes,
any other judgment?
yes, ma'am.
Any one more?
Lord, little tomorrow, there I.
Tomorrow.
Yes. Lord, before adjourning this matter, my appeal to your lordship is, let this matter be listed after 10 or 15 days. Let the commissioner be appointed.
No,
Let-
all.
Lord, otherwise,
All-
Lord, the purpose of making the application would be vitiated.
Everything.
Lord, let a member of the bar be appointed as a commissioner, I don't mind. Let him go to the spot and verify whether the development has made or not. Lord, the entire land is barren. No layout, no development.
Tomorrow.
Not,
Tomorrow.
Lord, I'll be out of station tomorrow. Anyway, Lord, Mendabela. Okay, tomorrow I'm prepared, but let this application be considered.
Tomorrow. All tomorrow.
Please, the interim order to be extended. Lord, sorry to make submission. Lord, relying upon this, at least let this honorable court could know the real fact on the scene of the suit schedule, the land in question, whether the development activities have been done. See, your lordship could, if a commissioner is appointed and he submit the report, I honestly feel that your lordship would kindly really appreciate.
Tomorrow for orders.
On the application, you know.
All.
No, still my submissions are not over. I have a few more judgments to be placed on record and a few more facts to be stated.
Tomorrow you want
Please.
to make submission, you can make submission.
Please, Milo.
You want to make submissions tomorrow?
Yeah.
Make it. At 11.
Cons. My lord, twice the matter has been not reached. Twice the matter has been not reached.
What can be?
It may be posted today after tomorrow.
My lords,
May I mention item number 15, lord, 50, lord. Since I am coming from Delhi, lord, and this matter was heard in part, lord, on 3rd July. I was waiting for my turn today, lord, but unfortunately it did not reach, lord. Any, lord, next week, lord, your lordship may accommodate things, lord. On 24th or 25th July, lord. It has been heard in part, lord, on 3rd July.
In a week thereafter.
Lord,
Then, lord, 3030.
My lord, serial number
My lord,
42, my lord. My lord, serial number 42, the matter has not reached in the past 2 occasions. I request for a date in the next week, my lord.
serial number
25th, my lord. At first week of August at least, my lord. First week of August at least.
my lord.
I'm so grateful.
Next matter, my lords.
51.
Serial number 16 matter has not reached for more than 4 times. Coming and it is not getting reached.
to kindly give a certificate and not reach more than 4 times, please, after 4 weeks.
My lord, my serial number is
Serial number
72.
18, my
It is
lord.
ಸ್ವಲ್ಪ
Next
ಸ್ವಲ್ಪ
matter.
My serial number is 72. It's for office objections. First time it is coming. A week time actually.
Since how long it has not reached?
Anyhow.
Since how many times it did not reach?
That's a very important matter, please. It's very important urgent matter.
4 times.
No, first time it is coming.
First time.
First,
And next week.
next week.
My lord,
Next week, please.
Serial number
my lord,
51,
serial
my
number
lord.
18, my lords. My lords, matter pertaining to the university for the syndicate, body of the syndicate, my lords. My lords, more than 1,500 colleges, my lords, without affiliation.
Rajiv Gandhi.
Tomorrow, my lords. My lords, not take more than 10-15 minutes, my lords. My lordship has heard it in part.
That can be had on Monday,
My lords, more than 1,500 colleges, my lords. We have completely stalled, my lords. My lords, the functioning has stalled, my lords.
20.
My lords, tomorrow, my lords, because my lords, 1,700, what I want to my instructions are, my lord, more than 1,500, up to 1,700 colleges. We have not granted affiliation. No inspection has happened. My lords, because the body, my lords, with respect to, my lordship only clarify the interim order, my lords. Thereafter, my lords, we will not press for. Only with respect to clarification of the interim order, my lords. Tomorrow, my lords. Tomorrow.
Tomorrow I have some difficulty.
My lords.
Monday may not be.
My lord, tomorrow, my lords, other council, only with respect to clarification, my lords.
Syndicate meeting so far.
My lords, we are not able to do because of the interim order, my lords.
Syndicate meeting they can have.
My lords, without the, if they concede to that there is a new, with,
Wednesday.
Serial number 51, my lord.
Serial number 74.
Serial number
That's
51.
Wednesday.
74. The office of it only one matter. They are requested to file a copy of the affidavit matter. I had filed the matter. And then serious threat of disposition matter. All the way from the interim order.
My lords.
Serial
My
number
lord, serial number 47.
51.
Next.
What is the request?
My lord, serial number 47,
Your
short date may kindly be given.
Serial number.
Your
It's
request.
coming up.
I had complied the office objection, my lord. And a serious threat of disposition, my lord. All the way in the writ petition, my lord, interim order is there. And next week for preliminary hearing.
2nd August.
My
Serial number 51.
My lords,
In
number
that, my lord, we have taken-
serial number.
We have taken steps for 3 times and
3 times.
yes, my lord.
Did not reach.
Need. So we will take a notification, paper notification.
It did not reach for 3 times.
Sorry, my lord.
Your matter did not reach for 3 times.
No, my lord. The matter steps to R4. So it did not serve. So we'll take a paper notification and there is an interim order in this matter, my lord.
So what do you want?
So interim order to be extended
2 weeks.
till the next.
2 weeks.
My lords,
My
serial
lords, in
18, my
item
lords.
number 54,
Matter is clear, then not because of the matters pertain to the matrimonial case, he has to make payment. If he having some financial crisis.
6th August.
My
6th August.
My lords, in
copy has
item
been
number
not received in
54.
the same case, my lord. Kindly post it for 4 weeks time, my lord.
The already office objection has been overruled by this court and notice has already been sent. They have said that notice and again they have said that upper office objection they have filed. This is the orders of this honorable court. They have overruled the office. And they have posted the case for to serve the notice to serve. I have served the notice. And it may kindly be posted for to hearing.
Yes.
My lords, serial number 18. My lords.
21st
August.
August.
August 21st August for hearing. Already notice has been served.
18th August.
My lord, no.
Yes.
My
Serial
lords,
number
serial number
47, my lord.
Permitted to serve the copy of the interpretation authority. The last occasion, lordship by directing the serve notice. Take notice. Maybe all the respondents are authorities.
Let's see the.
Serial number 98, my lord. Have produced the judgment of this honorable court. The past at least runs about 100 pages, my lord. That I have not enforced, my lord. I have produced the first page and from the beginning of the judgment I have produced the annexure R and S, my lord. And annexure A is the I have challenged the section 89A of the BWSS Act. I have produced the relevant portion of the act and the first page. That was produced before the learned single judgment. Now I have made the submission, the same office, that office objection may kindly be over.
Oh, it's been,
98.
it's been, yes.
I have sought for stay, my lord. It may be posted on
Taken.
Monday, my lord, Monday.
My lord, serial number 47, it's a contempt application.
46, your lordship. It's a contempt matter pertaining to promotion of the officers, your lordship. It may be had first week of August.
When do you want?
Third office.
Third,
It's in
third is,
that matter we have issued, DPC has been conducted, my lords. It may be taken up after 10 days, my lords.
third will be almost 2nd of August.
Let's serial number 18, my lords. My lordship has posted for Wednesday, some inconvenience for senior, inconvenience, either Tuesday, my lords, request for Tuesday.
My lord, serial number 47. It's a
Bill number 25, my lord, content matter for the appointment of the 10 minutes. Date may be fixed. My lord, serial number 28, my lord.
Let serial number 90, 95.
Court officer.
Yeah, office objections are complied.